on 29 and 30.
For motion.
One is for motion, another is for order.
Okay. Sorry. Oh, four. I think you have to make a mention in code number 4. Code number 4.
Oh,
That is the first bench. Taking a bench 4.
May pleases your lordship. May pleases your lordship.
Yes, yes.
Your lordship, I beg to mention item number 10, taking consent of the other side, your lordship.
10.
5.
Item number
Item 5.
5.
Yes, sir.
Okay.
Instruction awaited, your lordship.
There is an
There is an interim order.
interim order.
Okay. We'll have it for motion after 2 weeks.
Yes, your lordship.
On the prayer made on behalf of the respondents. List after 2 weeks to enable obtaining of instructions. Puts the para. Interim order passed earlier to continue till the next set of listing.
Deeply obliged.
May I please, your lordship. So for
Yes.
item number 31 is concerned, tomorrow there are series of cases have been listed in the court number 17. Item number 20 starts from item number 20, lordship. So item number 31 is also similar that eviction matters, lordship.
Have it tomorrow.
Yes, sir.
It is submitted, item number 31. It is submitted by Sri R. Dhar, Learned Counsel for the petitioner that similar matters are listed tomorrow. Full stop. As prayed for, list this case tomorrow along with WPC
WBC 7976-22.
7976
22.
22. What is the stage of those matters?
Lordship, that eviction matters, lordship.
What is the stage of those matters?
Tomorrow, final order will be passed. Lord. As per
But this
the.
is for motion.
Yes,
What
for
is the
eviction.
matter? Okay, okay.
Yes, sir.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 33, my lord.
Yes.
On behalf of Mr. P. Sharma for AFDC, my lord. Lordship may fix the matter after 2 weeks, my lord.
Yes, Mr. Burago has been informed.
Yes, yes, ma'am.
On a prayer made on behalf of Sri P. Sharma, Learned Standing Council, AFDC, matter stand adjourned by 2 weeks. Is there any interim order?
That I don't know, my.
Huh?
No.
Item number 33.
33, my. Obliged, I
May it please, my lord. My lord, item number 19, my lord, 19.
Yes.
It may kindly be taken up after 4 weeks, my lord. Last week of April, my lord. We have taken consent of the respondent railways
Here for the petitioner.
petitioner, my lord.
On a prayer made on behalf of the petitioner, matter stand adjourned to be taken up
The 4 weeks, my lord.
after 4 weeks.
Obliged.
May I please, your lordship? With the consent of the petitioner side, lordship, I beg to mention item number 29. This matter, Mr. Senior Counsel Vijay Mohanta has been appearing as standing counsel.
21,
So 2 weeks, lordship?
taking the consent.
Yes, yes.
29. As it is submitted that Sri T.J. Mohanta, Learned Senior Counsel, appearing for the Guwahati High Court, is under bereavement. Full stop para. List after 3 weeks.
Yes. Obliged.
Yes.
May I please?
Is there any interim order? No interim.
No.
May it please your lordship. Lordship, items 47 to 49, lordship. Lordship, I pray that your lordship may take up the matter at 2 o'clock, lord.
47 to
49, lordship.
what are these matters?
Lordship, tender matter, lordship, tender work is complete. Lordship, it's been almost 200 days. We haven't received the payment, lordship. Although the tender was challenged.
47
lordship.
to 40?
9, lordship. 47 to 49.
Cannot assure, madam. If it reaches, we take it up. You have difficulty in the first half or what?
Lordship,
You want to
first-
upgrade?
Lordship, upgrade to 2 o'clock, lordship.
No, you want to upgrade or what?
Lordship, upgrade.
Upgrade is, sorry. All matters are important. We'll try, but
Lordship.
let us see. We may reach also.
Wait,
Thank you.
I beg to item number 20, my lord.
20.
20. There is some subsequent development, my lord,
Hmm.
in respect of the matter, my lord.
Hmm.
Let the matter be taken immediately after, my lord. So I can,
18 matters, Mr. Hussain.
yes, my lord.
Sri M. Hussain, Learned Counsel for the petitioners, yes, submits that there is certain development in this matter, full stop para. He accordingly prays for, and he accordingly prays for some time, full stop para. Matter is accordingly adjourned to be listed after 4 weeks.
Immediately, my lord.
4 weeks.
Interim is there, my lord.
Then we'll give it to be listed on 19th of April.
And
Interim order passed earlier to continue till the next date of listing.
May I please, Your Lordship, I beg to mention item number 21 and 22.
Yes,
Will vote the matter
infructuous. You are Bibi Burwa,
L. Burwa.
L Burwa, right? MS L Burwa, Learned Counsel for the petitioner, submits that by flux of time, the matter has become infructuous. Excise Department, anybody? This has become infructuous. 3D Gogoi, Learned Standing Counsel, Excise Department, as well as D.K. Sharma, Learned Additional Senior Court Advocate for the state are present. Writ petition accordingly stands dismissed as infructuous. Separate orders 21 and 22. Huh? Yes.
May I please, Lord? May I please, Lord? I will beg to mention item number 4, my lord.
4 years.
This item may be taken at 2, my lord. Due to misplace of my record, I could not bring the record.
Okay. Motion matter.
At 2.
Lordship, in item 59 supply, there is a requisition. If I shall provide.
Yes.
Please, Your Lordship. But the petitioners are the holders of the land adjacent to the forest land. But respondent authority, without following due process, without demarcating the land with the land of the petitioners from the forest land, they forcefully evicted the petitioner number 1, and general notice was issued for evicting all the petitioners from the land in question. My lord, here in this case, kindly see, one PIL has been filed. In the said PIL, my lord, there was a specific direction that page 70 is the relevant portion of the direction.
70.
70. The suo motu PIL. Paragraph 70, point number 3. The development deputy commissioner should be of the Gwalpara district and divisional forest officer Gwalpara shall conduct survey of encroachment made in the forest area within a period of 3 months from the date of receipt of the copies of the order, and shall immediately initiate steps for eviction of such illegal encroachment in accordance with the law. However, it is clarified that while conducting eviction drive, the authority shall follow the due process of law. And all the petitioners, my lord, are the patta holders of the land. I have annexed the document of Chitha, my lord, either in the name of the petitioners or in their forefathers. The petition,
Patta holders.
yes, patta holders.
Where are the documents?
Documents, my lord, kindly see page 35 to 38.
Yes, Mr. Gogoi.
Earlier, my lord, when this case was taken up, my lord refused any interference. And I was directed to get the instruction whether, my lord, I have clear instructions that these persons are, my lord, encroachers. So, my lord, my lord, this survey is limited to persons, my lord, who are outside the boundary, my lord. If there's any encroachment, these persons are immediately, my lord, encroachers, my lord. That is the reason.
What about the land document?
Land documents, my lord, these are disputed, my lord. We are disputing these documents. What has happened, my lord?
You have to file an affidavit.
No, my lord, this has to come and revenue has to step in, my lord. Revenue is not a party out there, my lord.
Revenue is party, my lord.
Revenue is not a party, my lord. Circle officers have been made a party. As such, revenue department is not a party out there, my lord.
You make revenue a party.
My lord,
Since your papers are disputed, we will grant you some kind of protection, but
my lord, this
he is raising a very serious kind of a dispute.
these are all chithas, my lord.
Understood,
Yes.
but he is raising a serious kind of whether the contents of the chita or the
Chitha.
chita as such may not be authentic, or maybe there may be some error.
Respondent number 7 and 8 kindly see the circle officer who is the revenue authority. 7 and 8.
I think 7 and 8 you can get the instructions, Mr. Sharma.
And Thereapart, my lord, that
And
Supreme Court ruling,
four
my lord.
also, my lord.
If, my lord, irrespective of mode of ownership, if it is in a, my lord, in records, if forest land is a forest land, my lord.
Have to, but forest land, how can you grant chitta?
Yes, my lord, that we have to see, my
In
lord.
fact, my lord, petitioner is admitted, my lord, to the court.
Where?
My lord, I have just gone through the, my lord, synopsis. Which name? But they are
No, no. We have said that it is a pita holder. We are patta holder.
So paragraph 2, I think averments are there, Mr. Sharma. Come to paragraph 2 at page 10. All the petitioners have their patta land inherited from their respective predecessors and have been paying land revenue regularly and are enjoying their rights, title and interest over the respective land by constructing dwelling house. That statement is there.
Maybe,
In fact, my lord, confusion has come, my lord, because of this kind of.
And my lord, deputy commissioner is also made party. Respondent number 4.
My lord, they have annexed the.
My lord, if there is a genuine, we have no case.
No, Mr. Sharma, prima facie, he has made out a case that if he is a patta holder, then also you can acquire the land, but there's a different process. You cannot term them as encroachers. If you want the land, acquire the land in accordance with law.
Right.
But, and what Mr. Gogoi is saying, is just not saying, is indicating that this, he has some doubts over the document. For that, you need to ascertain, but simply having doubt will not do.
Yes.
He has prima facie shown something to the court which gives an impression that he is the patta holder.
And
Make the Sita
all-
copy, my lord.
All the documents, my lord, if I have downloaded from the website also. It is not that we have prepared it.
No, I'm not saying that, my lord. Maybe the cause behind all this.
Even downloading, there may be some error, there may be some fraud. You don't, we are not saying that
Yes, ma'am.
anything now. What is indicating that this appears to be a part of the forest land? If it's a part of forest land, then there is no
Then
question.
I have no case also.
Yes.
But
Arts free, SK Ghosh, Learned
My
Council.
lord, prior to. Pray my. Here, my. If they arrive, my lord, survey copy to them. The commissioner and secretary revenue department also, my lord.
I will serve copy.
Arts free, SK Ghosh, Learned Council for the petitioners. Also heard. The petitioners. Full stop. The petitioners who are 26 in numbers are aggrieved by the action of the respondent authorities in purporting to evict them from their respective plots of land, which according to the petitioners are patta land and patta land which has inherited upon them from their predecessors. Full stop. The petitioners have also annexed copies of the chittas containing their names. Full stop. Para. On the other hand, comma, Sri D. Gogoi, Standing Council, Forest Department submits that the eviction drive is in accordance with an order passed by a division bench of this court in a suo motu PIL. He also raises doubts on the authenticity of the land documents annexed to the petition. Full stop. Para. Perusal of the list of respondents would show that Revenue Department has not been made a party. Full stop. Para. Issue notice returnable on yes. Returnable on 10th of April. Is it okay? 10th, Monday.
My lord, it may be 12, my lord.
Last 12, my lord.
Let it be on 19th.
My lord.
19.
19.
19.
Remember 19th. The Gogo Island Standing Council, Forest Department accepts notice on behalf of the respondent numbers 1, 2, 3, whereas Sri D.K. Sharma,
Five also.
5, yes, 5,
Five.
6, 5, 6,
Five, sir.
whereas Sri D.K. Sharma, learned additional senior government advocate, Assam, accepts notice on behalf of respondent numbers 4,
8, 7 and
Seven.
4, 7, and 8. Full stop. That extra copies be served upon the learned council for the parties. Full stop. At this stage, this court is of the view that for a complete adjudication of the list in hand, comma, the presence and participation of the revenue department would be necessary. Full stop. Accordingly, that you have a commissioner secretary. At the commissioner secretary, revenue department, whatever department, disaster management, revenue department, we made a party respondent. We made party respondent number 9. Such insertion is permitted to be made by hand by Sri Ghosh, the learned counsel for the petitioner. Stop. The said respondent number 9 would be represented by Sri A. Bhattacharjee, who accepts notice. Full stop. That extra copies be served upon Sri Bhattacharjee too. Full stop.
But some in-
The learned council prays for an interim order. Full stop. Para. Prima facie, on perusal of the documents, including the cheetahs, it appears that a prima facie case has been made out by the petitioners, and they have stated that they are still in possession of the land in question. In view of the above, take the returnable date, status quo as on today be maintained so far as the land in question.
petitioner's land in.
Acknowledgement.
Hello. Non-payment of contractual bill method.
Non-payment of compensation,
Contractual.
contractual bills.
Yes, ma'am. Of Water Resource Department.
Where is the acknowledgement? Where is the acknowledgement?
Page 30 and 31.
Hmm?
Page 30 and 31.
Work is of which year? 2012.
12, 15, last 15.
Hmm?
12 to 15, my lord.
Where is the last work order?
Fourteen, 14, maximum 14, 18.
Where? Where? Where are the work orders? You have got a work order at page 15, which is of the year 2012. And this acknowledgement by the executive engineer, is it sufficient in accordance with the full bench, Tamsir Ali?
My lord,
Tamsir Ali says that the acknowledgement of liability should be by the chief engineer.
Not civil engineer, it is executive engineer.
Civil engineer. There has to be some reasons for the full bench to identify a particular officer, chief engineer, in the rank of chief engineer. By the executive engineer, works are of 2012-13. You have come to the court in 2023. And this liability statement, even if we term this to be a liability statement, it is given when? 2021. Yes, Mr. Who's for the irrigation department? You, water resource. How do you calculate this seats at annexure 3 in the year 2021? What are the records?
I have to take the instruction.
Take instructions.
Lordship.
And liability statement to the petitioner under what basis? Did he apply for?
Yes, my lord.
Where is your application?
We have applied, but they have not agreed to supply furniture.
No. This statement, how did you get it? It is addressed to you. It is not even an inter-office communication. Simply some officer would like that you put out an application. See, your entitlement, we are not at all against your, that you shouldn't get your entitlement. But this involves public money. We have to be very careful that whether there is any abuse, misuse of public money. One find one officer who was not even connected with the works. He gives a liability statement without any there being requisition. You take instructions. If he is entitled, then the questions of limitation and other things will come. But first, you have to come to a conclusion that he has done this work and this is the amount pending. The delay and all will come in later on. Two matters, similar.
Also similar matter.
Okay. The matter pertains to a claim for contractual bills for works done. Full stop. The works are seen to be of the works mentioned have been claimed to have been done long time back of almost a decade, and the liability statement which has been issued by the executive engineer has been addressed to the petitioner without there being any reference. Full stop para. Sri R.M. Das, Standing Council, Water Resource Department, is accordingly directed to obtain instructions. Full stop. List for motion on 2 weeks. 2 weeks. They give a date, motion matter.
Hello. In case
On 10th.
case 29, it is addressed to Mr. Petitioner.
That is it. Why did he address? That is the question we are posing to you. Without there being any reference, somebody will write to you that you are entitled to so this much of amount. Was there any application under RTI? Was there any representation of yours? Okay, 10th. Let an extra copy of the writ petition be served upon Sri Das during the course of the day. In both the cases. Separate committee. Yes, next.
Hello, this is a matter relating to declaration of the willful defaulter. Your lordship may kindly see page 310.
310.
My lord. This circular issued by the Reserve Bank of India, my lord. At page 312, my lord.
What is 310?
At close 213, my lord, willful default at the bottom, my lord.
Please, good luck.
313,
This is RBI guidelines.
my lord.
1st of July,
My lord.
1715. Page 312.
312, my lord, at the bottom. 213, my lord. 213,
Willful default.
my lord. Willful defaulter will be deemed to have occurred. Any of the following events is noted. Now, there are four clauses, my lord. One is the unit has defaulted in meeting the repayment obligations for the lender, even when it has the capacity or honor to the sale obligation. The unit is defaulted in making the repayment obligations in the lender has not replied the finance from lender for the specific purpose for which the finance was availed of, but has diverted the funds to other places. The unit is defaulted in meeting the repayment obligations to the lender and has siphoned off the funds so that the funds have not been utilized for the specific purposes for which the finance was availed of. Where are the funds available with him? Unit in the form of this assets. The unit is defaulted in making the repayment obligations to lender and has also disposed of or removed the movable or and fixed assets or movable property given for the purpose of securing a term loan without knowledge of the so-and-so. These are the four reasons below for which a person may be declared to be a willful defaulter. Now, my lord, I was issued with the identification notice, my lord, at page 225. 225, my lord. Pointing out the defaults. My lord, at page 226.
This 225 is what notice?
My lord,
This is what notice?
this is identification of the default effects, my lord.
Oh,
And I was directed to rectify the aforesaid defaults within 10 days from the date of receipt of the said notice. Now, I submitted.
this is identification of default.
My lord.
Hmm.
Now, I
You are there, you are here,
My lord.
you're here, all of you.
Yes, sir. All the directors and company. Now, my lord, I submitted reply at page 228.
238. Yes.
At page 229 below, I mentioned that the reasons for which the was said that I'm defaulter, 3 reasons were given below at page 229 in the bold below.
Yes.
Due to non-payment of interest and installments obligation, even when you have capacity to honor said obligation, due to diversion of funds, due to siphoning of the funds, so that the funds have not been utilized for the specific purpose for which the funds was availed of. Now, at page 230 below,
Yes.
below you also may see. It transpires that your letter notice that you have carried out the scrutiny of our loan account unilaterally and without seeking any information, data, reports whatsoever from us, and availed of the conclusion and arrived at the conclusion that these have not been events perceived willful defaults, that it seems to be a so-and-so. The letter noticed by so-and-so events received understanding order to decide on account borrowers, grantors, willful defaulter, in terms of RBI guidelines, there should be a well-established and express narration of the events quoted by the reliable transactions and so and so. So, my lord, we said that, my lord, simply on the basis that, my lord, we perceived one person cannot be declared to be, my lord, a willful defaulter. Now, you will also may kindly see, my lord, at page 234. We made a clear, my lord, that The letter is not supported by any document, paper substantiate the so allegation against us. So you may when action is taken. So the documents and papers on the basis of which my lord the decision was arrived at, that should be forwarded. Then my lord, a so-called notice was issued to me at page 235. Lossy may see kindly page 236, my lord. Siphoning of the funds. As per the stock audit report dated 22/10/2020, the sales of the units were so and so crore and the credit summation CC account was so and so during the period from so and so so and so. The sale is so and so crore and the credit summation is rupees so and so. The company is not routing their funds through the CC account. There are also some differences in the stock transactions submitted vis-a-vis the books of account. The insurance of the stock less than compared to the stock of the unit credit summation and so and so. In your case, you so and so. So also may see that say that stock audit report dated 22/2020. Now that was not forwarded to us, no report was given to us. Now we submitted reply at page 38. Also may see the siphoning of the funds. We stated, my lord, that the report has not been forwarded to us. And if the report is forwarded to us, then we can go through it and then only we can submit a reply to the same, my lord. And page 239, my lord, your lordship can see. Under the head capacity pay, you might have considered past balance sheet figures as the date of balance sheet has not been mentioned specifically, which is checked as on the current date had changed drastically due to the developments happened after the non-disbursement of the sanctions also. Because that conclusion was arrived by the bank, my lord, on the basis of the past balance sheet, not taking into account the current balance sheet. Now, my lord, I submitted a further reply as 240 at the relevant part at page 243. Later is at 243, my lord. And at 244, in the middle, my lord, I stated that a complaint was made to the Central Vigilance Commission, and the report of the Vigilance Commission has also not been forwarded to us. Now, at page 247, you'll also see, my lord. I gave the net worth of the company and other thing, my lord, of the directors as on, my lord, the current date, which I reproduced, my lord, all the charts. And this was, you'll also find in 250, my lord. I gave them a credit summation report from 2015-16 to 2019-20. At page 251, you'll also find the 1920 at the bottom, my lord. Now, in spite of that, my lord, the order was passed declaring the petitioners to be willful defaulters. And thereafter, my lord, a committee of identification will has to be reviewed by the committee of the identification, my lord, which you'll also find at page 257.
What is the function of the committee?
Well, after the order is passed, the committee reviews it.
Review committee.
My lord. Now, lordship may see 258, my lord, the bottom two lines. The directors, guarantors of having means to pay bank dues, but they are not paying. The net worth of the guarantors are as per table below. Page 259. The lordship may see siphoning of the funds. As per the stock audit report dated so and so, total sales were so and so crores and credit summaries of so and so, so and so. Thereafter, you also may see there are some differences in the stock statements submitted vis-a-vis the books of accounts. Credit summarization in the account does not commensurate with the sales of the unit. Thereafter, the regions. Lord, I again submitted reply at page 261.
261.
And the Lord, at page 263, again I stated at 8 and 9, my lord. That the relevant documents or papers were not given to me, to enable me to submit a proper reply. Further, again, reply was, my lord, submitted on page 285 and 11 part at page 292.
Yes.
I gave the personal balance sheet as on 31/3/2020 of all the persons classified from 292.
Dr. Saraf, your main contention is that their basis of taking this initiative, this action is upon perception only. There is no objective satisfaction, which you are asking them to
Supply materials.
supply.
I will also page 306, my lord.
306.
Hello. The last three or four paragraph. The guarantors have submitted.
Just a minute. Yes, please.
The guarantors have submitted that their present net worth means is negative as per the narration in the reply. But the review committee with the view that as per the CR dated so and 20 and so and so, the actors guarantors have net worth to repay the bank dues. Further, the summation of the net worth submitted by the guarantor are not CS certified and they are not can be relied on. My lord, if the bank wanted the CS certified, they could have asked for the CS certified, but they have not asked for the CS certified, and whatever the data were given, they have just ignored the same. One paragraph, my lord. The review committee took note of the fact that the relevant portion of the stock audit report, which shows the borrower and his directors have siphoned off the funds, shows that the sale proceeds so and so has been provided. Now, my lord, one page of the stock register, that was given to us. Now, unless until the entire stock report is given, let's say 11 part, that is one page only, we cannot find out from the one page that what is the position. Now, this issue will not come up before the similar issue before the Bombay High Court. We are also just see. Six. There are 6 just 8 or 10 lines from the top below. Against that order, paragraph 6, page 6, just 8 or 10 lines from the para 6. Against that order,
yes.
Petition number 1 preferred a review application as contemplated by the master circular. In that application, while seeking to substantiate state that it was not liable to be declared a willful defaulter, demand was made for supply of certain documents that have been referred to in paragraph so and so of the review application. Other grounds seeking reconsideration were also raised. The result of the order passed by the review committee indicates that reference has been made to the demand of documents. After reproducing the factual aspects, it has been observed, review committee, that the replies furnished by the company and directors were not supported by documents and hence statements were not tenable. The review committee had not considered the request for supply of the documents as made by the petitioner. It expect whether these documents are demanded, were relevant or not, had not been considered. Therefore, may skip over, my lord, and may come to my lord. paragraph 7, last 2 lines, my lord. Though it is true that the request for supply documents was made by the petitioner before the review committee, it was necessary for the committee to have at least considered such request and given reasons for either accepting or declining that request. Perusal of the improved note does not indicate consideration of such requests. It need not be emphasized that the procedure prescribed in the master circular of willful default issued by the Reserve Bank of India is mandatory in nature. Though it was urged on behalf of the petitioner that the order of so-and-so passed by the review committee was signed by only 1 member, aspect was denied by respondent 1 to 3 by filing additional affidavit to persuade the order. That is so. We do not find it necessary to go into that aspect. We find that the review committee has failed to consider the request made on the behalf of the petitioner number 1 for the supply of documents. They are thus on account of the failure to consider the request made on behalf of the petitioner 1 to supply the necessary documents. The matter required reconsideration at the hands of the willful defaulters review committee, and for the reasons of so-and-so, the order so-and-so passed by the willful defaulter committee is set aside, redirected so-and-so. As your lordship, my lord, without the judgment also, your lordship is well aware that when any action is sought to be taken on the basis of, my lord, any materials or the documents, my lord, then it is necessary for the principles of justice, my lord, that those documents and papers are supplied to the person concerned to meet and reply on the basis of that. And when a specific request is made, my lord, the documents should be supplied. Then order cannot be passed without ignoring the request. Now, in this case, we have given the details. Now, the bank is going on by the data of 2018 and 2000 data they are simply ignoring on the ground that this was not CS certified. Now, if the bank wanted the data to be CS certified, they could have asked me that you give the CS certificate documents. We could have given it, but it cannot be just ignored on the ground that no, these were not CS certified. If there was anything that the CS certified documents were asked for and we have not given, they can come to adverse finding. But without coming to that, asking us to give a CS certificate documents, and may not just arrive in the conclusion that no, we are CS certificate, we will go by the 18 documents. 18 documents and 2020 documents, 2020 documents, the net worth is minus, then one cannot rely on the 2018 documents to come to a willful faulter. So far as stock register audit report is concerned, the report is,
my lord, my learned friend has argued as if he has filed an appeal. Your lordship is an appellate forum. Now, my lord, before starting with the merit of the case, your lordship will find this corporate insolvency resolution process, they have opened it. This company has filed an application under section 10, my lord, to declare them insolvent. Now, my lord, that petition is pending, and they have other 3 companies. One is Navia Agro. That, my lord, CRP process is over and the account is closed. So for other 2 companies, JSB and Trey and Bairihat Coal, resolution plan approved by the NCLT. Now all the companies are like that, and my lord, there are some business jugglery, my lord. As a lawyer, we cannot understand all these things. There are certain things he could not succeed there. So therefore, my lord, these are the application they have filed. And I will take your lordships.
No, let us make it a way. Coming to the last submission,
My lord.
we have not accepted the submission of the accounts of the guarantor on the ground that those are not CA certified.
My lord, I will take your lordships
No,
to
no.
the what we have
If we give him an opportunity, if we can supply a CA certified submission, to consider in your past orders.
My submission would be, can a parallel proceeding go on? They have filed a suit also, my lord. Now is before the NCLT, and again they have come here. And your lordship kindly see what is
That is for the same cause of action.
same cause of action.
well, that was for the recovery of the bond from the bank. Well, I'm just clarifying, I'm not deferring. That is recovery of the bond from the bank. These are all different matters, my lord. Here, otherwise there was no necessity of declaring to bank defaulters, willful defaulter.
My lord, your lordship kindly see, I will take your lordship to all that. Now, your lordship kindly see the sanction letter which is page 90.
No, we need not go to the documents. He is based his case upon on the premise that there is no objective grounds which have been made available to him to come to a conclusion to initiate this proceeding.
No, whether this
and it is based on only perception.
My lord, whether it's a very genuine submission or not, I'll clear it up. Your lordship kindly come to page 105.
105.
the terms of the sanction letter. One zero five clause 16, my lord. The borrower shall deal with our bank. Banks under consortium multiple banking arrangement exclusively shall not open current accounts. Your lordship kindly see this word. Shall not open current accounts with any other bank without prior permission. The borrower's entire business relating to their activity, including deposit, remittances, bills, checks, purchase, non-fund based transactions, including LCs and BGs, forex transaction, merchant banking, any interest rate or currency, hedging business, etc., should be restricted only to the financing banks under sole banking consortium. Now, your lordship, I'll take your lordship. This is why important. I'll take your lordships to understand. Then your lordship kindly come to page 225. This is the Shoko's letter given to them. Identification of default in the loan account of Messrs. RH Agro Product. The company is under moratorium under section 14 of the ISB code. Now, your lordship kindly see in the next page, at page 226, due to non-payment of interest and or installment due, the seed account has been classified as
225 is the notice.
Shoko's notice, yes.
556.
225.
5621.
5/6/2021.
Notice for?
Then your lordship kindly turn to
Notice
next.
for what?
Pardon?
Identification of default.
Yes, yes, yes. Now, page 226, your lordship kindly see. Due to non-payment of the interest and or installment due, the said account has been classified as non-performing asset by the bank in term of RBI guidelines on 31/3/2021 with balance outstanding 47 crores 31,64,652 and odd.
NPA.
NPA. It has been declared way back on 21. On scrutiny of the said account, the following events of willful default are perceived due to non-payment of interest and installment obligation, even when you have capacity to honor the said obligation, due to diversion of funds, due to siphoning of funds so that funds have not been utilized for the specific purpose for which finance was availed of. You are therefore called upon to rectify the aforesaid default within 10 days from receipt of this notice, failing which we shall be constrained to recommend your names to the identification committee to declare as a willful defaulter in consonance with the RBI guidelines. Now they have been given time and they have replied, and we are not satisfied with the reply. Then, my lord, once again, your lordship now come to page 235. Shoko's notice dated 5/10/2021. Now, at page 236, siphoning of funds, as per stock audit report dated so and so, the sales of the unit were 63.32 crore and credit summation in the CC account was, your lordship kindly say how much it has come? 101.16. If your sale is 63 crores, how come in your account 101 crore? Then during the period of 1/4/2020 to 39/2020, the sale is rupees 101.39 crore and the summation is 2.89 crore. My lord, the lordship has seen the sale is 101 crore and how much in the account? 2.89. Now they are saying their explanation is that we have deposited in another account. Now can it be, my lord? What is the sanction letter?
You cannot open. You cannot open.
They cannot open, my lord. Now this is the way they are diverting the fund. Now this itself explains the entire thing. Then your lordship kindly see, there are also some difference in stock statements submitted vis-a-vis books of account. The insurance of the stock is less as compared to stock on the of the unit. Right now, supposing this is not correct, they could have explained, they could not explain anything. They are saying, give me this paper, that paper. In case you will agree by the aforesaid conclusion of the identification committee, you may make a submission, representation, if you so desire, to the identification committee for consideration and shock as to why you should not be classified as willful defaulter. The submission representation must reach within 15 days of the receipt thereof. We send to so and so, so and so. The undersigned is the member of the now lordship. This is all they have given some explanation, all back explanation. We are not satisfied. Then, my lord, the lordship may kindly see, come at page 257. Is the order of the committee for identification of willful defaulters. Now, my lord, I will take your lordships to page 259. Siphoning of funds. Has your lordship got that?
14,722?
14.7, yes. This is for order of the committee of identification of willful defaulters passed in proceeding. Now, at page 259, as per stock audit report dated 22/10/2020, total sales were 63 crore and credit, your lordship has seen that earlier. The same thing they have referred here.
At 258,
259.
259. Yes, which one?
Your lordship has seen that siphoning of funds
Hmm.
in the earlier pages.
Hmm.
An order of the committee for identification of willful defaulters. The identification committee headed by the executive director and consisting of other members, that is chief general manager, deputy general manager of the bank, found that the charges against the borrower and its above named directors, guarantors, stand proved for the reasons and facts stated above. Therefore, the said committee recorded the fact of willful default committed by the above persons mentioned at serial number so and so as willful defaulters for the cause and reason mentioned above. However, the committee members directed that the borrower and its above named directors, guarantors are free to make a written representation against the order of the identification committee within a period of 15 days from the date of receipt of the order to the review committee headed by so and so, so and so. The undersigned is the member of the identification committee constituted so and so, so and so, authorized and undersigned to send this order of the committee for identification of willful defaulter. Now, my lord, once again, we have asked them by the review committee, that is at page 303. The letter dated 7/11/2022. In terms of RBI Master Circular number so and so dated July 1, 2015, Committee for Identification of Willful Defaulters.
You are reading it to 303.
303, my lord, on the from the top, my lord.
1711.
7/11.
711, right.
My lord. In terms of RBI Master Circular number so and so dated July 1, 2015, Committee for Identification of Willful Defaulters issued show cause notice dated 5/10/2021 to the following persons, mentioning the grounds on the basis of which they are identified as willful defaulters. Now they are a company and the my lord directors, guarantors.
One is the company.
One is in the company is under moratorium now. While show cause notice, the above named persons were given opportunity to make representation if they so desire to the bank within 15 days from receipt of notice as to why they be not classified as willful defaulters. Thereafter, representation.
What was your activity, Mr. Saraf, Dr. Saraf? What was the activity? Fertilizer. Fertilizer product or what?
My lord,
क्या बिजनेस किया आपने?
नहीं है तो उनको देख।
The name suggests that Agro Products Limited.
It is mentioned that the performance money is referred to a company was engaged in the business of manufacturing of edible vegetable oils. Para 2.
Possibly mastered well. Now, in the show cause notice, your lordship can see, but show cause notice the above named persons were given opportunity to make representation if they so desire to the bank within 15 days from receipt of notice as to why they be not classified as willful defaulters. Thereafter, representation dated so and so were received from the company against the show cause notice dated so and so, by which the opportunity of personal hearing was sought. Pursuant to the representation from the borrower director against show cause notice, opportunity of personal hearing was provided to them with the direction to appear before the identification committee on 25/5/2022. The personal hearing was attended by Kamal Kumar Harlalka, director of the company, for himself and as an authorized representative of the director's guarantee. After considering the representation and submission made by so-and-so, the identification committee, by order dated 14/7/2022, issued the order identifying the borrower and its directors, guarantors as willful defaulter on the following grounds as specified in the master circular of RBI. Now, the first issue is in terms of the master guidelines, my lord, they must have the capacity to pay, and it is held that they had the capacity. Now, your lordship will find at page 304. As per CR of the guarantors, they are having enough means to pay bank's dues, but are not paying. The net means of the guarantors are as per table below. Now, your lordship will see that is the capability of the directors. Now, next point is siphoning of funds. As per stock that your
What
lordship
is
has
the
seen
CR?
earlier.
Year of the guarantors means first line at page 304.
304, my lord, the total net worth they have 17.10 crores.
Now what is CR?
CR, which one? That is crore, my lord.
No, no,
For CR dated.
no, no. As per CR of the guarantors means
As per CR of the
304 first
guarantors.
line.
Yes, yes, I have seen that. As per CR of the guarantors.
CR
they are
means?
having enough. क्या है? Credit ratio. Lord, my learned friend is expert. He's saying it is a credit ratio.
You are an expert.
No, my lord, he'll not admit, but he's an expert.
He is. Credit ratio, okay. The guarantor.
Now, the credit ratio, as your lordship has seen, 17.10 crores.
Where do you get?
That is a summation of all from Kamal Kumar Halalka to JSB and Trade Private Limited. Now,
You have made the summation.
no, if total made, it will be more than that, my lord. It will be 27. My lord, it will be over 33 crores. So this is the financial capacity.
33 crores, how?
My lord, if all these we make a summation, it will come to 30, I think 1.52, then 0.55. If all these, तुम ही कर दो ना. So this is the financial capacity of these persons.
They are the directors.
Yes, directors, guarantors. Then all these things are pending before the, my lord, the NCLT, and they themselves filed an application, make them insolvent. And if we say it is not correct, I'll place the necessary papers. And then, my lord, siphoning of funds, the next issue.
Mr. Dr. Sahib, if you have invoked the IBC for declaration as insolvency,
The company.
would this amount to contrary proceedings?
The company invoked the provisions for declaration.
Mhm.
One of the creditor, unsecured creditor filed a petition before this honorable court because he was not a party, and so this honorable court passed the judgment, my lord, that the time period within which the resolution is process is passed, that was over, and thereby they cannot proceed further. And that matter is now pending in the writ appeal. Status quo order is there. There is nothing, my lord. It has not been passed. The resolution process has not been approved by the NCLT in many because it is barred by limit. The period of 330 days was there. That was expired. And on that ground, it has not been approved.
Writ appeal against which order?
My lord,
Writ appeal against which order?
it appeal against the order of only single judge, by which, my lord, there was one single judge held, my lord, that the proceedings before the NCLT, because the petition was filed by the company. One of the secured creditor, unsecured creditor, my lord, he filed a petition before the court saying that, my lord, because the resolution process, he has moved it before the NCLT, but the unsecured creditors, my lord, that interest is not protected. So he filed that, my lord, the second extension which was given by the tribunal, which was against the provisions of the code, and thereby the second extension for the completion of the resolution process could not have been passed. There is a specific bar in the court, my lord, that second process is going to be. In any case, my lord, 330 days is the outer limit, my lord. And the court said the 330 days is also expired, and thereby the 330 days can only be, my lord, extended only in case the resolution professional take steps to put the corporate debtor back to his feet. And they said that since the resolution professional said that this is not the process of putting the resolution professional, the corporate debtor to be back to his feet. Thereby the court said, my lord, that no, 330 days extension cannot be granted. Against that, my lord, the resolution professional filed a writ appeal, and the writ appeal is pending. The court has passed an order of status quo. That means as it is today, the resolution plan has not been approved by the NCLT, and the status quo is prevailing. At present, my learned friend is saying about the merit, my lord, that what is the amount, what is not the amount. I am not on that, my lord. My lord, they may declare me to be willful defaulter if after going through the facts and after going through the certified CS certified documents and all those things. And in this case, my lord, the apex court in one of the case had laid down the consequences, serious consequences of declaring to willful defaulter. And after laying down it, the court has held, my lord, that the Article 91 violation is there because they must pass a regional order giving all the reasons. I will give a copy to your lordship, my lord, that judgment.
Because of this type of bad loans, the economy of the country is in
Don't
a
say
danger.
about 50 crores of my bad loans. Think of the 5,000 crores which are there.
Where,
after the bad loans.
I
of the
don't know
economy.
why you're thinking about
No,
others.
he's saying that
We are
the
in this case.
economy is suffering because of my 50 crores.
The people like you, I am telling.
Not people like me. People.
That's why, my
because
lord,
of the
these
bank
cases,
issue.
these sort of cases should be
This is
seen.
the bank. My lord,
Okay,
the
let us.
there are 9
They
million.
will take the
5,000
money,
crores.
and what they do, my lord, they'll go to
What I will do, how you know? What we do?
my lord, the main modus operandi is what you lordship
It is
know.
very difficult to know that.
That-
What
Yeah, wait.
there are
Go
9
to,
million.
go to NCLT.
Hard, Doctor. Yes, sir.
Para 9 and 24.
No, you file your returns.
My lord, it's better.
Ah.
Some jagah mein case kar rahe.
Something is required in the code also at times.
Beg your pardon.
Charge up.
No,
Some
this is,
charging up required.
No, no, only thing is,
these charges are, my lord, a bit of drama process.
no, my lord, the only thing is that he said that their models of 20, how we will know that our models.
My lord,
bank-
as a lawyer, we understand something.
Drama, entire thing is drama.
Yes, yes. And these things, how it happens, everybody
Life
knows.
is a drama.
You know,
Yeah,
some-
That's why I'm
all
saying
the-
that how it happens, everybody knows. In spite of that, 5,000 crores is given and.
You're
it
not
is
on the
given.
case. You're on a bigger drama.
He's in a bigger drama. I don't know whether he's a party.
Everything
to this.
directed by somebody. You are just acting.
No, our duty is only to acting. with-
After some time, he will talk about Nirav Modi and all that.
No, why are you talking?
And
to Nirav Modi?
ultimately, his position will be
I am
like
not-
Rahul Gandhi.
Or that, yes. Now you give me the level of Rahul Gandhi. I have no objection. If you can make me to such a level, my lord, what is the harm?
You are not MP or MLA, that something happened.
The petitioners who are 11 in numbers have put to challenge an order of review, an order passed by the review committee for declaration of willful defaulters dated 7/11/2022, by which the company in question and its directors oblique guarantors have been declared as willful defaulters. Full stop. The principal contention of the petitioners is that the bank has undertaken a process which is unfair and not transparent, by which proper opportunity has not been granted to the petitioners to show cause when the proceeding was initiated. Full stop. The bank has also, it is the contention of the petitioners, that the bank has also relied upon factors which are irrelevant and extraneous. And if a proper and reasonable opportunity was granted to the petitioners, there would have been no occasion to pass the impugned order dated 7/11/2020. Full stop. On the other hand, the S. Dutta, a senior counsel, appearing for the bank on instructions have submitted that a parallel proceeding is going on in the NCLT Guwahati, in which the petitioners have filed an application for declaration and for declaring the company to be insolvent. Full stop. He further submits that the proceeding has been initiated strictly in accordance with law by giving all reasonable opportunities. Full stop. The issue involved would require some deliberation. Full stop. Issue notice returnable by 6 weeks. Three. Your name? A? A? Upamanyu. Sri K. Upamanyu, Present Counsel, assisting Sri S. Datta, Senior Counsel for the bank, accepts notice on behalf of respondents. 1, 2, 3. 1, 2, and 3.
1, 2, and
Why this
Three,
is
my
a
lord.
pro forma respondent, RHS Agro?
It's because they filed a petition in the NSA. So we have not made them petitioners, my lord, because we cannot file the petition on behalf of the RSC. We are on the behalf of the directors and the guarantor.
You're not, the company is not before us.
No, company not.
the company is under moratorium, my lord. That's the reason.
Company not under moratorium. Company filed a section 10 petition.
That we understood.
So we have.
But this action which you are impugning is not against the company as such.
Well, we are the directors and the guarantors who have come before us.
No, but the action which is under challenge 7/11/2022, it will not affect the company.
The company may.
Definitely.
Company may affect, but since the reason is that if the director declared a willful defaulter as per para 9 of the judgment of the appeals court, the consequences are that the directors cannot.
Defaulter can be attributed to a person, not to a legal entity.
So it can be legal entity, it can be person separate, every individually. It's company, all the director individually, the bank.
Not understood. Company can also be in default.
Company can also come, but at present, we are the directors and the guarantors who have come before us.
My lord, your lordship may have, because of that reason, this read petition is not maintainable at all.
Why you are suggesting the court that we have.
No, this is my submission. I'm not.
That's a fact. In fact, while dictating, we were under the impression the company is the first respondent, first petitioner.
The notice you also see is issued to different
This
persons.
issue will also. It is seen that the company has been made pro forma respondent. Also, let notice be, let steps be taken for service of notice upon the respondent of 5. But this will be 4. Kindly make the correction.
I'm
Respondent of 4 by registered post to change. 4 the 1, 2, and 3 extra copies. What is the present stage now?
So this order has been passed. That is the stage.
And this is of November.
Hello.
What is the effect of the order?
The effect of the order is para 9. You'll also see the judgment it mentioned. What is the effect? That I just.
What are the adverse consequences in your?
No additional facilities to be granted to the bank financial institutions, to the persons who are declared willful defaulter. Entrepreneurs, promoters would be barred from the institutional
We
finance.
do one thing then, we fix a date, we'll consider an interim prayer on the next date.
Yes, that is better.
On his, because this has come into effect in November, it will not be proper.
But
We'll have 1 month.
at least further action on the basis of this will not be done.
My lord, at this stage, my lord, can your lordship?
Returnable on, give the date, but you have to file your returns before that. We'll not grant you more time. So give a date of your convenience. Mr. Doctor. 27 is today.
My lord, after 3 weeks, your lordship.
No, we'll have it date fixed.
Yes.
We'll have it on 20th of April.
20.
20.
All right.
28th April. Also, Dr. Saraf, the Senior Counsel, prays for an interim order. Also, considering that the order challenge is of November 2022, this court will consider the efforts of prayer on the returnable date after filing of the returns. Bank Sri Datta is to ensure that the returns are filed before the next date.
That is no further action to be taken, but your lordship will consider the stay of the order that is on.
Further action is almost
No, further action will be now, not, my lord. The further, yeah,
After that, what further action?
Lordship, so far as the order, stay of the order is concerned.
no, that is it. Tell us what kind of adverse action you are contemplating.
You will also see that I cannot go anywhere. Para 9, the consequences have been narrated. Of the judgment, my lord, what are the consequences?
My lord, after hearing that order can be passed.
No, I understand
Because-
fully. I'm not asking for the stay of this one, of the stay of the order. my
No,
lord.
not.
The lordship has.
From November to March,
Some protection.
from November to March, you have been able to sustain 1 more month. Not now. We'll consider.
Much
But you file your returns. And
Yes,
give him some time to make a response or take instructions from his client. Not on the last date.
my lord. Same. Obliged.
We have fixed on 20,
20.
Thursday.
If that, on that day, they fail to file the affidavit.
Then we'll consider. We'll
You'll
consider.
also make object, my lord.
No, I will file, don't worry.
Only you have not filed for 1 year also.
Yes, next. Mr. Chutia, you are directed to have instructions.
We have the instruction, my lord, due to the objection, my lord, by the local people, my lord, for construction of the building, my lord, they have filed the PL and they have obstructed, they have raised the objection of demarcation also on that date. So we have.
PIL is there.
No, PL has been disposed of director to make an inquiry. PL was that, my lord, if that plot of land is included, my lord, they have that, they will escape it of the some non-government educational institution act, my lord. So we have fixed, my lord, 5th April is the next date for demarcation, my lord. If there is no objection, my lord, then we can demarcate it on that day, my lord. Lordship may fix it after view vacation, my lord. Or notice may be issued also, my lord.
This court wide order
Fifth
dated
April.
22/3/2023 had directed Sri J. Chutia, Standing Council, KAAC, to obtain instructions as there was apparently another litigation connected, full stop. Sri Chutia, the learned Standing Council, has obtained instructions as per which the next date fixed for taking out the exercise of demarcation is 5th of April 2023. Full stop. In that view of the matter, this case on 10th of
After view vacation.
on 19th of April to enable the Chutia to obtain further instruction. Yes.
Please allow. And lordship will see the first, my lord, item number 9, my lord. The last order was that, my lord, lordship can have a look.
9 is 835.
My lord, there is an IA, my lord. Because, my lord, there is a 2 ferry guards, my lord, I have challenged by way of 1 writ petition. Then your lordship was pleased to ask me to take legal steps. So that,
You filed one.
yes, and IA I have filed for dropping the name of Rajnagar.
That will consider. So the first one will be
Rajnagar. First writ petition will be the Rajnagar only in respect of Rajnagar.
Rajnagar phrase. No, first you are striking down Rajnagar. Oh, in the second.
Yes, lordship is still looking at WPC, my lord.
No, we are having a look at the IA.
IA, my lord. IA, my lord. So we have filed for segregating, my lord, dropping the name of Rajnagar.
From which
the
one?
Second writ. Item number 9. 835.
Forward, this is not the procedure. The first writ petition is 1606.
1606.
They had two ferry ghats. We said that you may have a cause of action, but you should come separately.
Yes.
Then the ideal course is to file a second one in respect of only one, and in the first you file an IA not to consider for the second. Second one is also for both.
My lord, second one is the for both, my lord. I find
First one is also for both.
no, first one only for Rajnagar. Only Rajnagar.
1606 is only for Rajnagar.
My lord. Rajnagar. Page 22.
835.
No, my lord, 1606.
Okay. 1606 is the second one. Okay. Okay, we thought that this was of 22. That will take care, yes. No, what about the main case?
In case lordship will, in item number 1606, lordship has to issue notice. And second case, my lord, 835, the IA,
First, we dispose of the IA.
my lord.
Third, Sri J.I. Borbia, Learned Counsel for the applicant. Who, by means of this application, has sought to delete one part of the relief paid for in WPC 835/2023. Full stop. It is the case of the petitioner that initially the aforesaid writ petition 835/2023 was filed being aggrieved by the process of settlement of two ferry ghats, namely,
Rajnagar and Jhating.
where do you get the names?
In the
My
order-
name is Jatinga
And
Ferry Ghat and Rajnagar Ferry Ghat. So, this court, while considering the matter, had expressed the opinion that though the nature of grievance and the relief paid for may be similar, but the cause of action are distinct, for which two writ petitions would be necessary. Full stop. Accordingly, the petitioner the applicant had subsequently filed WPC 1606/2023, restricting his claim only for Rajnagar ferry service. Full stop. Consequently, the instant IA has been filed to delete the challenge pertaining to Rajnagar ferry service from the present writ petition WPC 835/2023. Full stop. Also heard Sri R.M. Goswami, Learned Counsel, appearing on instruction on MD Bora, Learned Standing Counsel, Transport Department. Full stop. After hearing, the instant IA stands allowed, and the challenge pertaining to Rajnagar ferry service is deleted from the purview of challenge raised in WPC 835/2023. Then what about those are in 1606 we have to pass orders, I think. Yes. Yes. Right in 1606/2023. Heard Sri J.I. Borbia, Learned Counsel for the petitioner. Full stop. It appears that the challenge made in this writ petition is with regard to the process of settlement of the Rajnagar ferry service. Full stop. Sri J.I. Borbia, the Learned Counsel for the petitioner, has submitted that initially WPC 8/35/2023 was filed. Was filed concerning two ferry services, including the Rajnagar ferry service, in which this court, by order dated 17/2/2023, had issued notice and also passed an interim order directing that no further action be taken for settlement of the ferry in question. Full stop. This court had also observed in the said order that since the causes of action are distinct and separate, different writ petition is required to be filed. Full stop. Accordingly, the present writ petition has been filed along with filed simultaneously, and interlocutory application I-678/2023 has been filed in the earlier writ petition WPC 8/35/2023 to delete Rajnagar ferry service from the purview of challenge. Full stop. The said IA has been allowed today by accepting the contention of the applicant. Full stop. Para. Since earlier, notice of motion as well as interim order was passed also in respect of the present ferry service, namely Rajnagar ferry service, in WPC 8/35/2023, as a formality, such order is required to be separately passed in the present petition. Full stop. Para. Issue notice returnable by 4 weeks. P. R.M. Goswami, learned counsel appearing on instruction of MSMD Bora, standing counsel Transport Department, accepts notice on behalf of responsibles 1, 2, 3, and 4. Let extra copies be served upon him during the course of the day. Para, as already held earlier in the other writ petition, it is directed that till the returnable date, no further action be taken for settlement of the Rajnagar ferry service, which were under contemplation in the decision of the tender committee meeting dated 12/1/2023. List along with WPC 8/35/2020.
My lord, in 8/35, my lord, interim order to be continued.
You have filed your returns?
No, my lord, did not file.
In 8/35, you're right. List after no, now the prayer of Sri R.M. Goswami learned so for this list after 3 weeks to enable him to obtain instructions, let's file a fit in opposition. Interim order passed earlier to continue till the next date of listing.
101606, my lord, WPC, respondent number 5, my lord, will be register post.
There is 5 also. Earlier there was no 5.
5 there is.
But there was no order passed.
And
five.
in that case, there was, we have taken steps.
Oh, 5 close. Here. Extra copies, RM Goswami जो वो इसमें लिखा था 1665 और एक line, steps for service of notice upon respondent number 5 be taken by registered post to DD, steps within 2 days. That order में देख लिया 8/35. दोनों
Made please your lordship, matter relates to cancellation of GST registration, my lord. There's supposed to obtain instructions, my lord.
Lordship, Lordship has passed earlier orders. Lordship can pass similar orders.
You have orders, copies.
Yes, Lord.
Mr. Mishra, make the corrections pencil.
A factual difference, my lord, I will tax,
Yes, and you. Are those disposed of?
Yes,
my lord.
Lordship.
Yeah, Mishra, B. Chaudhary, Namdi. R.S. Mishra, B. Chaudhary. Sending call.
Item number 10, 11, 12, and 34.
Lordship, 12, there is one thing, Lordship, he has come after 1.5 years. Lordship, he has not prepared any appeal, but he has come after 1.5 years. The reasons are not, Lordship.
I have given the reason, my lord, because of financial crimes, I could not file my returns. After filing returns, I have come, my lord. After complying with all the defaults, I have come, my lord. After payment of filing of return, payment of tax, I have filed, my lord.
Lordship, in that case, he will have to apply for new registration, Lordship, after paying all liabilities, because it's 1.5 years.
My lord,
Lordship.
in all the cases are cancelled.
Lordship, others 3 months, 4 months, Lordship.
Item number
5
12,
months.
item number 12. Okay. The B. Chaudhary, the sending council, however, submits that there is inordinate delay of 1.5 years, which has not been explained. Full stop. He further submits, and therefore to get the benefit, comma, the petitioner has to apply afresh and pay all the dues.
But if I will apply for it, it will be difficult for me, my lord. I have already paid all the taxes, my lord. I have complied with all the defaults, my lord. Other can, if I have not my registration, my lord. It will not.
No, other than yours, there is a difference. Others has not come after 1.5 years.
But it was between the pandemic period, my registration was cancelled, my lord.
Okay, we'll consider.
My lord.
We'll see.
Oblige, your lordship.
Proceed. Submission rate. Come, 5 minutes.
Order to correction का अपन देखा लेंगे।
তোমার খালি ফটো করে লবা বা এটা ডাউনলোড করে লবা এগুলো তাকে সাথে তো একটু ডেট দিলা বলি
बोले यार फिर रिटर्न फाइल करना सी
তোমার
देखा लो
টাইম পিরিয়ড Assam State Execution and Execution of Land Act 1964, my lord. Put over bridge, my lord.
Where?
At Palra Bazaar. And at the time of notification, my lord, it has been notified that this will start from KC Chain Road to railway station. But now, my lord, it has been converted both the sides of the road. So for this purpose, my lord, some eviction drive needs to be carried out by the Amazon. For this purpose, my lord, they have issued notice to the Fatadar. In under section 3 of
Fatadar.
The Fatadar land is required here, my lord.
That has to be acquired.
Acquired, my lord. But my lord, section 3 of this Act of 1964 of Assam. Assam Land Acquisition and Acquisition.
Landlord, yes, sir.
Section 3, your lordship, you can see.
One second, let us have the text. Yes, 964. Section?
Section 3, my lord.
Yes.
Power to requisition. And for this purpose, under subsection 1 of section 3, notice is required to be given to the Patadar. Now, you lordship cannot see subsection 2. An order under subsection 1 shall be served in the prescribed manner on the owner of the land, and where the order relates to land in occupation of a tenant, also on such it. Much of right, my lord, I am saying. They are not giving any opportunity of being heard.
You're a tenant.
I'm tenant, my lord. All are tenant. They are not hearing us, not giving us any opportunity.
Yes.
We are having, my lord, absolutely temporary shop.
But first of all, let them place the agreement, my lord, with the landlord. What is honorable court to establish that, my lord, they are well, legally, my lord, tenant.
My lord,
Where is that, man? There's nothing, my lord. In fact, my lord, they've already been heard. Lordship may kindly turn to page 79. There's a series. They have submitted representation, they have been heard.
And there is substantial compliance of two. Even if you take
They
it,
appeared before the hearing, my lord.
if you raise an issue, though technical is a substantive issue, land acquisition, you are entitled to notice. We will not hold this to be a technical and overcome, but this amounts to substantial compliance.
no, my lord. Notice has been given to us. We have submitted representation. Our representation was rejected along with the representation of the landowners. Without hearing us, my lord. Your lordship may cannot see document number.
Page 79, my lord, is also.
Page 79, my lord. Usual proceedings, page 79, my lord, in section 9. Usual proceedings with the Patadar, my lord. And my lord, this order was passed, and only our signature has been taken. Much after. Without calling us in the meeting.
Where have you stated?
I have stated in
Where? That your signatures were taken later on.
well, paragraph 21, page 16, my lord.
Page 16.
Paragraph 21. We submitted our representation on 23/123 before the sworn, my lord. Thereafter, what they have done. 21, my lord. In spite of duly receipt of the aforesaid representation dated of the petitioners as respondents, but till that the respondents have not given any opportunity of being heard. Rather, on 7/2/23, the officers of the respondent number 2 came to the basis place of the petitioners and handed over a copy of the order dated so and so by taking their signature. We are not called for in the meeting, my lord. The copy of which has been served. We are not called for. Section 3(2) is mandatory, my lord. We are small businessmen, my lord.
But unfortunately, this is not verified as true to your record, true to your knowledge. How can this be a part of records? You say that somebody comes,
No, my lord,
takes your signatures, serves copy, and you verify to as per records.
no, my lord, because this letter had as annexure number 9 series, my lord.
So what? We want your requirements. How have we verified your requirements? You come to your affidavit, paragraph 21. It's not as per your knowledge.
Which is as per record, because my lord, that letter I had annexed.
How can it be as per record? If you're trying to derive a benefit from that statement that there was no hearing, can be a record of no hearing.
Obtaining signature by my
Can
lord.
it be your
that is
signatures given?
separate-
Is it a matter of record that you have given your signatures? You have written a letter. Is it a matter of record? Yes, you have received a communication from the authority. That will be a record. Your writing is not record.
So, my lord, service of letter is a matter of record, my lord. That's
Service of
why-
by them.
By the respondent, my
Where
lord.
is the paragraph 21? 21 is what? 21 contains a statement that on such and such date you are given a copy and your signature is taken. How can this be verified by true to the as per records? Records will say that your forceful signatures are taken forcefully. This is something you know personally.
But my lord, this letter, this document of which I have annexed as annexure number 9 series is apparently clear, my lord. This order was passed.
Yes, Mr. He says that these were done only principally for the landlords.
My lord, yes.
And their signatures are taken only as a matter of formality. That is,
My lord, that part, my lord, before that he will have to establish that, my lord, he is a tenant, my lord. In this regard, only one document has been annexed, page 91, lordship may kindly see. These are certificates, my lord, issued without any date. In the same format, my lord. In
91
respect
series,
of
my-
all the
91 series,
petitioners.
my lord, in respect of all the.
Yes,
all the
lordship may kindly see the contents, my lord. I so and so, Colton Madan is so and so, do hereby certify that Bijan Das, son of so and so, is my daily basis tenant. From whose date, my lord, not indicated, who has been running his business of clothing Dallas in front of the portion of my Patalan, which is being covered so and so. TS pavement in the western side. This is the
These-
only document we have placed.
these are all on footpaths, Mr. Nala.
Yes, cannot be, my lord. Colton
Yes.
Madan, no, my lord, these are all footpaths.
On daily basis can be a
Yeah.
tenant.
Yes.
Just inside over the portal.
Is there any campus in Polton Bazaar? If you know a bit Polton Bazaar, we also know Polton Bazaar.
But our establishments are over the portal and my lord.
But not possible.
My say, my lord, I am not saying that I can stall the eviction proceeding, but my lord, I should be given an
Counsel.
opportunity of being heard. And some compensation should be given to me, my lord.
For the petitioners. Examine. The petitioners who are 11 in numbers have challenged the action of their eviction by eviction,
Proposed eviction, my lord.
by their proposed eviction, by taking the provisions of the Assam Land within bracket requisition and acquisition bracket close Act 1964. Full stop. The case of the petitioners are that they are petty businessmen who are on a daily rental basis from their landlords and doing their business in the Paltan Bazaar area of Guwahati city. Full stop. Recently, the petitioners had come to know that a foot overbridge is being constructed from the KC 10 road to the railway station, for which there would be for which land would be acquired under the aforesaid act. And in fact, certain notices have been issued to the landlords. Full stop. However, no such notice as contemplated under section 3 within bracket 2 have been served upon the petitioners. Full stop. He submits that the requirement of notice being mandatory, the petitioners cannot be, the petitioner cannot be displaced from the area. Full stop, para. On the other hand, comma, Sri B. Gogoi, Learned Standing Council, GMC, has submitted that apart from a statement made that the petitioners are tenants, comma, no documents worth its name has been annexed or referred to in the petition. Full stop. Though certain certificates have been annexed, comma, those cannot in any manner be termed as a rent agreement. Full stop. He submits that the petitioners are encroachers and who are given space just in front of the premises by various owners of properties, and they are not entitled to any notice under the Act, as the same is not applicable for such petitioners. What's the para? The issue would require some deliberation. Issue notice returnable by 4 weeks. The Gogoi revenue and Botler, the understanding concept revenue. Have notice on behalf of respondents.
1 year.
1, whereas 1 and 1, 2 is DK Sharma, Learned Additional Senior Government Advocate. 2 and 3, I think. Circle officer, Guwahati Revenue Circle, circle officer, government, 2 and 3. Whereas 3.
Or 4, I mean.
We go for standing council PWD for response number 4. That extra copies be served upon the Learned Council for the respondents by tomorrow. Any action taken pursuant to the notice in question shall be subject to the outcome of the case.
In that case, can it be a short date instead of 4 weeks? Because there is a public interest involved under it.
You go ahead.
Because-
Yes. This is kind of solace you'll give to the clients.
But in the beginning, Lordship has recorded that I am standing council GMC. It should
No,
be-
no, PWD, huh?
Right.
PWD, huh? Okay, next.
Yeah, please. I'm having one item 25, my.
Hmm.
In this case, my lord, the affidavit in reply has been filed just now. Item 25.
Here for whom?
I for the respondent number 4.
I'm the petitioner number 2 in this case.
You're appearing in person.
Yes, Lordship.
What is the matter about? We'll take,
I'll file my counter, my lord.
he wants to file his
Lordship,
counter.
today itself I filed the affidavit in reply.
You filed your affidavit,
Affidavit
you're
in
the
reply, Lordship.
petitioner.
Yes, Lordship.
You filed what?
I filed counter affidavit, my lord.
Then he's filed a rejoinder.
The agenda is just filed, my lord.
What, there is no question of further pleadings.
What counter is.
No. You can have instructions from your client, what to say, what not to say. Otherwise, it will be an unending process.
Only once on chance may be given. my
What
lord.
chance? As a respondent, what is your chance?
My lord, for
Chance is to file a counter affidavit. You're done.
countering certain documentary evidence.
Where is the scope? Tell us.
Let's-
After a repetition, counter and rejoinder, where is this further scope? You have to take leave from the court. Not a matter of routine. We will not allow.
No, I'm not claiming.
We won't
anything
allow
by
unless
right.
you make out a case
Some-
that entirely
my
new
lord,
facts
By
have,
going,
entirely new facts have been pleaded, new documents have been brought into record. We'll not allow you. We'll,
my lord.
you can make, you take instructions from your client, make a submission and consider.
That has been taken place, my lord. Because by prevailing beyond the repetition, some.
We'll see at the time, at the time of admission. You will have it for admission when
After review, my lord.
your name,
Diganta Varman, Lordship.
Sri D. Varman, has appeared in, petition number 2 has appeared in person, who submits that the rejoinder affidavit has been filed today.
Yes, Lord.
3N alum, learned counsel for the response number
4.
4. Prays for some time to obtain instructions. Full stop. List after 2 weeks for admission. What is the matter about?
Relating to eviction and the inaction on the part of the GMD, my lord.
For
Not taking any step against illegal construction, my.
Okay.
Whereas, my lord, in that area, GMD is not applicable.
which area?
Pamo area.
It's outside the
Outside the
limit of GMD.
No, Lordship, it is covered under the GMD area, Lordship.
Master plan.
Yes, yes. Under the master planning here, Lordship.
Outside GMD area, my
Okay,
lord,
we'll see.
I have placed on record.
We'll consider.
Highly obliged, Lordship. Please, Lordship. Petition against the rejection of the legal petition filed by the petitioner on the ground of non-appearance, Lordship. And the fact remains that the notices for fixing of dates were never served upon the petitioner.
Isn't there any power for restoration?
Petition that matter may be restored because the gross violation of natural
Rejected.
rejected, Lord.
Representation for restoration rejected. Yes,
Rejected.
Mr. Go anything?
My lord, here from the order, it appears, my lord, as the ex parte order. So, my lord, let me have the instruction whether actually it has been served or not, notice has been served or not, or the date fixed has been intimated to the petition or not. Only
But
that.
I think you should, it matters,
Yes, it can be otherwise reverted back. That's all we have not
Remanded.
served. madam.
remand it back.
So let me have the instruction, madam, one,
Okay,
on Friday, madam.
Friday. Third
Copy of the
is item number
14.
Dr. A. Todi, Senate Counsel for the petitioner, who is aggrieved
Whether it is-
by an order dated 12/1/2023 passed by the revisional authority, by which the revision petition of the petitioner filed under the Assam Value Added Tax 2003 has been dismissed. Full stop. It is the case of the petitioner that such dismissal has been done only due to default on the part of the petitioner, which he has explained was for the reason of non-receipt of any notice intimating the dates. Full stop. Para. 3B. Gogoi, learned standing counsel, state GST, however, submits that he may be allowed some time to obtain the instructions. Full stop. Para. This for motion on
Monday.
Yes, sir. Monday.
3rd. What about Friday next?
7th,
So next Friday, 31st.
31st, I won't be.
3rd, there will be some, okay, motion, okay, 3rd of April. That week will be slightly hectic. 3rd of April.
Much obliged.
I give an extra copy to you.
Yes, ma'am.
Let an extra copy
Yes.
of the petition be served upon Sri Gogoi by during the course of the day.
Obliged.
May please, your lordship.
Hmm.
Your lordship, in this matter, one advertisement was issued by the CDP of South Karimganj ICDS project for the regular recruitment of post, amongst others, for the post of Anganwadi worker for 94 number Loharpara ICDS project, your Anganwadi center, your lordship.
Hmm.
So the petitioner being eligible applied for the post, your lordship, but on 17/2/2023, your lordship, a list of valid
This
candidates.
is not bench for,
This is payment.
go to bench three. It appears that the subject matter involved pertains to bench three. Put some registry to verify and list before the appropriate bench. Day after tomorrow?
Tomorrow, your lordship.
Tomorrow, Tuesday. Day after.
All your lordship.
Yes, my lord, the government has allotted, reserved the land for Moti Kabrastan. My lord, the pattas, my lord, the chitas, my lord,
I have annexed from page 37 to 43, my lord. There was around 7 vigas, 9 acres of land, my lord. At page 37, my lord, is the, my lord, the Chita, my lord, of the village. My lord. So 2140 is a dark number, my lord. Land has been, my lord, in the last column remarks, my lord, is for Muchi Kabas. So there were 3 darks, my lord, 2140, 2142, and 2145. So in all these, my lord, darks, my lord.
You want the land to be encroachment free?
Yes, ma'am.
Have you filed representation?
We have filed representation to Deputy Commissioner. my
Yes,
lord.
Mr. Sharma,
Direct,
you take instructions.
my lord. And
Heard.
thereafter, my lord.
Sri Alam, G. Alam, Learned Counsel for the petitioner who are petitioners who are aggrieved by the inaction of the part of the respondent authorities to invoke powers under Rule 18 of the settlement rules to make a portion of the of land measuring 2 bigha, 2 katha, 10 acres to be encroachment free. Full stop. It is the case of the petitioner that a plot of land measuring 7 bigha, 9 lecha, covered by dark numbers 2140, 2142 and 2145 in revenue village Sahar, Taranya. Part 2 in Ulubari Moza of Kamrup within Bekatam district, located at Lalmati, Ulubari, was reserved, has been reserved for burial of dead bodies of persons belonging to the Muchi community and is known as Muchi Kabarstan. Para issue notice returnable by 4 weeks. Is burial or cremation?
Burial, my lord. That of Muchi, my lord, they have to bury, my lord.
We are not aware. Mr. Sharma,
The pictures of Ravidas and.
but they belong to the Hindu community, isn't it?
Yes, ma'am.
Yes.
And then, my lord, they used to.
Have you taken instructions?
Yes, my lord, yes.
No, you may be correct. Even Buddhists, some of the communities.
There, my, but I have not heard.
We are in doubt.
Sure.
Sure, my lord.
Take instruction again, huh? That's okay. क्या बोला? Returnable by 4 weeks. 3 revenue. A Bhattacharya ji. Sending council revenue department accept notice on behalf of respondent numbers 1, 2.
I may accept 3, 4, and 5.
1 and 2. Mr. Alam, if when you make the commission, chairperson represented by the commissioner secretary, you don't need to make the commissioner another party. No meaning to it. Respondent numbers 3 to 4, 3, 4 and 5 are represented by 3. No, the notice for respondent 3, 4 and 5 would be accepted by Sri D.K. Sharma. Learned addition senior advocate some. So let extra copies be served on the learned counsel for the respondents.
Part to consider my representation.
Pendency shall not be a bar for consideration of the representation submitted by the petitioner. Yes.
Because of sudden medical emergency.
Oh, when do you want? Friday? on the prayer made by Sri F. Z. Mazumdar. List for motion on Friday. Friday to do. Of Rangpur Samabay Samiti Limited, Hailakandi. Sometime in 2007, there was no election. The office got. Nineteen, madam. Consider the. Number 2120-2013. Yes. Then, my lord, the direction was at page 20 to hold the meeting in accordance with law on the basis of a correct voter slip. Thereafter, my lord, the process for election was started at page 21. Process of correction? No, process of election. Election. Election was started in 21. Thereafter, my lord, none other case was filed. That, my lord, would find at page 24, my lord. 730022. And herein also, my lord, similar direction was passed, requiring them to, my lord, within a time-bound manner, at page para 7, page 29. In view of the submissions made by the Learned Standing Council, so and so has not been held for last 10 years, and having taken the note of the provision of so and so, is inclined to direct the registrar to do the needful to have a correct voters list prepared within a definite time frame and to ensure election of the elected body is held within an outer period of 2 months from the date of order in accordance with the provisions. Yes, yes. Then, my lord, the election was notified. My lord would find it at page 33. The schedule is at page 34, my lord. Yes. Now, what we find, my lord, when they went to vote, it was, my lord, there was a resolution adopted at page 38, wherein, my lord, the reservation in the manner at para 7 at page 38 was made, my lord. 38, my lord. Yes. To constitute the board of direction, the election will be held from 8 directors from weaker section, 4 from stronger section, 2 from women, and 1 from SC/ST. My lord, this weaker section and stronger section division is not there in the act. We, my lord, represented, we have made a statement, my lord, they said that they will be holding a single election. Weak and strong in the basis of what? Physical weakness or strength? Financial, economic, what? It's actually, my lord, economic. There is a, that share, there is some difference in the payment, my lord. What is the yardstick? My lord, they say that they are registered people as weaker or stronger, basing on the amount, my lord, each subscriber. There is a categorization. Okay. But, my lord, the act does not permit any such categorization. I'll place that one. Then, my lord, the elections were held, results were declared. The election was held only for the weaker section. The stronger section, 4 posts, 6 had applied, 2 withdrew, so 4 automatically uncontested. For that, my lord, I failed. Then, my lord, we made a representation at page 50. Within 3 days, we have to make this representation. We made it. Before the election results were declared. 27. Huh? 27 of the election rules. My lord. Page 50, my lord, we made a representation, but unfortunately, my lord, this point was not taken. Accordingly, a supplementary representation was made on page 51. What is your grievance now? My grievance is, my lord, these 2 representations have to be considered by the election authority. Till date, my lord, they have not considered, and the body is moving. My lord, we may not go into the merits whether it's got. We can direct the election tribunal to. Election authority is the, my lord, ARC.
My lord, that is correct. My lord, I may not have any objection in that regard. But the representation or the, my lord, election dispute, the objection has to be, my lord, placed before the election authority.
Yes.
Now it has been, my lord, filed page 50, my lord, before the ARC.
He is the election authority.
No,
he is not the one.
Not the election.
No. He is. It's delegated, my lord.
No, not delegated.
It's delegated. It's delegated to that authority, my lord. Election authority, my lord, it has been delegated. It's a registrar, a rule 3, my lord. My lord will have this, my lord. We already have. My lord would have the My lord, we'll have conduct election to the board of directors. So and so, so and so. Subject to the superintendent's direction and control of the registered cooperative society, the following officers shall have the power to conduct election as per section 41(1) of the act as delegated by the government from time to time. Last one, my lord. Assistant registered cooperative societies for subdivisional level societies. And all along, my lord, the notifications were being made by the ARCS. My lord. He is for conducting elections.
Exactly, man.
He is the election authority, my lord.
He
He is the conducting elections. Come to 27. 27, my lord, would find. Lordship. B, my lord, the election authority shall make an inquiry upon the dispute on the basis of the relevant records and pass necessary orders. My lord, will have 2F, my lord. My lord, election authority means the registered cooperative society or any officer or to whom the power of election has been delegated.
This delegation is only for conduct of elections,
My lord,
but there is no delegation for the adjudication of dispute or election dispute.
lordship.
You had a point, but that
Lordship.
is only explaining to.
So, my lord, if
restricted
this representation we had made in time, maybe for the wrong authority.
So
My lord, my lord may direct the registrar to consider it. But both,
Rather we'll do one thing.
my lord, will
Since
give
your
it.
bona fide was there in
Lordship.
coming to the court tribunal within 3 days, we will give you liberty to file a fresh
Lordship, before the registrar.
representation with inputs of Mr. Nair
My lord, I have only one reservation to that.
to give some more points and grounds. You don't allow that.
No, my lord, one submission. My lord, had it been within 3 days from the date of election, then it could have been. But the election was held on 5/2 and admittedly, my lord, the complaint was lodged on 9/2.
No, it's from
After
the
5.
No, it's from the date of declaration of result.
Yes,
My lord, the declaration of result was on 7/2, my lord.
cannot be, my lord, in terms of the rule.
Yes, it's there. 3 days from the date of declaration of result, and my lord would find it
When was the result declared?
7th, my lord. 7th. My lord will have in the petition itself. I have
Sir,
stated.
Taluka is apprehensive because he doesn't want your inputs to now come in.
No.
Do not allow new representation. Whatever is there.
The 5th election was there, my lord.
Okay,
and
actually you can
Result 7th.
senior counsel for the petitioner. Assisted by Shri Padgiri, K.R. Padgiri. Full stop. The grievance of the petitioners, considering the nature of the grievance and as agreed to by the parties, the instant petition is taken up for disposal at the motion stage. Full stop. It is however made clear that the disposal is on a technical issue without entering into the merits, inter se merits of the dispute. Full stop para. The petitioners who are
My lord, shareholders and shareholders of the
who are 2 in numbers are shareholders of the Rangpur Samabay Samiti Limited Hailakandi and is Hailakandi, full stop. The last elections were held sometime in the year 2007, whereafter due to certain eventualities, certain situations, elections could not be held, for which there were litigations in this court. Full stop. Ultimately, an election was notified,
on 5/2.
notified, culminating the elections on 5/2/20, culminating on holding of the elections on 5/2/2023. Full stop. The petitioner submits that the results were declared on 7/2/2023 and in accordance with the Assam Cooperative Societies election rules 2019, and an election petition has been filed, full stop. However, that has not been taken into consideration, full stop. On the other hand, Sri Talukdar, S.K. Talukdar and Standing Council, Assam, Standing Council, Cooperation Department submits that there are two inherent defects in the so-called petition. Full stop. He submits that firstly, the same has been addressed to the Assistant Registrar of Cooperative Societies, Hailakandi, whereas as per the rules, more specifically, Rule 27 of the aforesaid rules, the election, the petition has to be submitted to the election authority, who has been defined in section in Rule 2F, right?
Yes,
My
Lord.
lord.
2F. By referring to the aforesaid Rule 2F, the Land Standing Council submits that election authority means the registrar of cooperative societies or any other officer to whom the power of election are delegated, full stop. He further clarifies that though as per section Rule 3, the powers can be delegated to the Assistant Registrar of Cooperative Societies, that is only for the purpose of conducting the election and not for adjudication of disputes for which a special delegation would be necessary, which has not been done. Full stop. Period as it may, since it is sin, the second grievance, the second objection raised by Sri Talukdar is with regard to the period of limitation. Full stop. He submits that apparently the petition has been filed on 9/2/2023, whereas the elections were held on 5/2/2023. Both the aforesaid two objections, however, has been responded to by Sri Nair by contending that the fact of submitting the petition before the Assistant Registrar Hailakandi can be rectified by permitting the petitioners to submit such a representation, raising the dispute before the registrar as per law, full stop. So far as the objection regarding limitation is concerned, the senior counsel for the petitioners clarifies that the computation of the prescribed period of 3 days has to be done from the date of declaration of results, which in this case was 7/2/2023. Full stop. Both the responses have been fairly considered by Sri Talukdar. Full stop. Under the aforesaid facts and circumstances, this court directs that the petition dated 9/2/2023 submitted before the Assistant Registrar of Cooperative Societies, Hailakandi, may be resubmitted to the appropriate authority, namely the Registrar of Cooperative Societies, Assam, within a period of a week from today, which would be deemed to be in time as the initial petition to addressed to a wrong authority was within time. Full stop. On such submission, the Registrar of Cooperative Societies shall consider the same and after giving proper opportunity to the affected parties, pass a speaking order. Full stop. The entire exercise may be completed expeditiously and preferably within
3 months.
within outer limit of 3 months from the date of receipt of the same.
my lord has said page 50, 9-2. Now there is a supplementary one at page 51. I don't know.
9-2, okay.
51 is, my lord, no date.
No, 14-2. Follow.
14 is beyond.
No, it's in continuation of
No,
this.
cannot be, my lord.
In continuation of this.
Cannot be.
14-2.
If 7 is the date, 14 cannot be, my lord.
No, I'm
Within the
already
limitation.
Before the tribunal.
They will only submit 9-2, my lord.
No, the
It is.
point is here, my lord. That's why I said.
Where would you get 14?
14, my lord, because that point with regard to 10-3 was not taken.
No,
in
where
my-
do you get 14-2?
My lord, page 51.
Page 51,
Down
receipt,
below.
receipt date, my lord.
Receipt date, 14-2.
14-2.
Down below. That is 9-2. That is received on the same day. But this was in continuation of that.
What is the point you're taking?
My lord, here point that reservation, that weaker section.
You'll be given an opportunity of hearing, you to
Lordship.
raise that issue.
Lordship, my lord will only say, because my lord, others they'll say we'll only confine to that. This point they may not take up.
You'll
Lord,
be,
will only
you'll be entitled to raise legal issues.
Only that much, my lord, may make an observation. My lord. That much only. The legal issues I can use, but that much only.
In the hearing directed, the affected parties would be entitled to raise all legal issues that would be considered in accordance with.
Much like that. Deeply object.
Sarah, what is this?
So the petition was issued with a so-called notice at page 33, you know, 33, you know.
Yes,
for the demand of service tax.
okay, okay.
And thereafter the petitioner informed in the meantime, the dispute resolution scheme came. So the petitioner informed that he's going to avail the resolution scheme, you know. And thereafter, the petitioner availed of the resolution scheme. And the liability was also discharged at page 38, certificate. After that, this adjudication order of so-called notice was again issued.
Right. Yes, Mr. Abra. If you had given him the benefit of the scheme, matter had come to an end. After that, how can you reopen the matter?
And the appellate authority I filed appeal also. And the appellate authority will also be see at page 148.
Then what would be the meaning of the scheme? You're referring to the SBLDR scheme.
Yes, Lord. Subcontract. And he is only saying, appellate authority, that since the so-called notice was after 1/7/2000, 11/7/2019, and thereby this will not be applicable. And there is a direct board circular, that even after that was the so-called is issued, if somebody gives the declaration that he is not going to file appeal, then that will be applicable. That has not been considered at all. And even then, once they have discharged the liability, how they can, again go for the adjudication and appeal? Which may take up on some other day.
When you notice, our Dr. Saraf, Learned Counsel for the petitioner, assisted by Sri Anand,
PK Bora.
PK?
PK Bora.
PK Bora. For the PK Bora. The petitioner, it is the contention of the petitioner that an issue regarding the central GST was resolved by application by taking benefits of a scheme, namely SVLDRS scheme under the provisions of section 125 of the Finance Act, 2019. Full stop. However, even after such resolution of dispute, a proceeding was initiated under the same, raising the same cause of action, culminating in an order dated 6/12/2022. Full stop. Even the appellate, even the approach to the appellate authority has also been futile, as the impugned action has been upheld. Full stop. Issue notice returnable by 4 weeks. PSC Kyle, Standing Council, First Union of India. Medi?
Yes, sir.
Learned Standing Council, Learned CGC accepts notice on behalf of respondent number 1. Whereas PSC Kyle, Learned Standing Council CGST. Correspondence was 1, 2, 3, and 4. Let extra copies of the writ petition be served upon the learned counsel for the respondents by tomorrow. Sarah, heard the learned counsel on the interim prayer full stop. After hearing and considering that the dispute has already been resolved pursuant to a scheme, comma, there is no occasion to reopen the same on the same cause of action. Full stop. Therefore, comma, this court is of the opinion that a prior FSI case post stay is made out. Full stop. Accordingly, the impugned order dated 16/2/2022 passed by the Assistant Commissioner, GST and Central Excise, Guwahati, shall remain suspended.
And also the appellate order is.
Appellate order
Page
doesn't make any sense.
Yes.
Uh, including the appellate, including the order dated
6/12/2022.
6/12/2022 passed by the appellate authority.
I'm obliged.
Till the returnable.
Please, Your Lordship, I have the instructions to appear in this case. Your Lordship, please to see the order. I understand that I've seen this order. But at this stage, my lord, may I pray, my lord, that my case that was pending before the authority concerned, namely miscellaneous case 641 of 1920, that may be disposed of within a time-bound program. That will do the need.
It was a 5/20.
Yes.
We have to take the status. What is the present status?
Yes.
But your case projected was different.
Yep, that
You said
project
some
is that
records were
this
not
case was-
traceable.
That case was missing.
That is the projection. Case
is
records
it.
were missing.
That is-
We said that what can we do? We have to approach the authorities. In exercise of the powers under judicial review, can we ask them to trace out something which is untraceable?
But no, your lordship can
You
direct
take
them.
instructions. You take instruction. What is the status?
Yes.
I heard Sri B.C. Das, run senior counsel, assisted by
B.
B.
Doctor.
Doctor. For the petitioner. The petitioner is aggrieved by the fact that certain case records pertaining to Miss J case number 641/2019-20, pending before the circle officer, Guwahati Revenue Circle, is untraceable. Full stop. Para. Though this court had made an observation that for such grievance, the powers of judicial review may not be the approach to this court in exercise of powers of judicial review may not be the correct forum, the senior counsel for the petitioner has submitted that an observation may be made for expeditious disposal of the said case. Para. Let the status of the case, of the aforesaid case, be obtained, be obtained by the standing counsel for the revenue department. Full stop. Accordingly, let an extra copy of the petition be served upon MSN and Bodloy, who shall do the needful. List on.
After PU.
Who? On 10th. 10th, is it okay?
Yes.
Guwahati. Give an extra copy, Mr. Dutta. Next.
Extra copy. Yes.
Is your lord. I have filed an additional affidavit, if that's a record.
Has come or not? License?
Yes, my lord, may I first take your lordship to page 155?
Of the additional affidavit.
Yes, ma'am. There, the tenure of license has been elaborated. Tenure of license, the tenure of license shall be initially for a period of 5 years from the date of commencement of the license with a provision of further.
This is your,
renewal. Yes, my lord. The
What?
terms and condition for renewal will be governed by the catering policy of
155 number?
last, page 155.
Okay, tenure of license.
Tenure of license. Tenure of this license shall be initially for a period of 5 years from the date of commencement of the license with a provision of further renewal for periods of 3 years on satisfactory performance and payment of all dues and arrears and withdrawal of court cases. Renewal will not be a matter of right. The terms and conditions for renewal will be governed by the catering policy of 2010 and the instructions issued by the railway from time to time. The license agreement shall be as per section D of this bid document. Then may I take your lordship to page 161? My lord, where,
One second.
so my lord, clearly the catering policy of 2010 is applicable, which provides for renewal. My lord, page 161.
This narrates about the license which you are required to hold.
Yes, my
Where is
lord.
that license?
Master license agreement is at page 198, lordship.
198. On this one, okay. Has been renewed.
The
Has it been
railway has
renewed?
mandated under the catering policy of 2010. And
Has it been renewed?
no, my lord, that's why I'm here before your lordship, aggrieved by the impugned order at page 23. Further, my lord, 132 of the writ
One
petition.
second, for what were your facts? Just reiterate the fact. What is you are operating from Guwahati and Kamakya railway station,
Yes, my lord.
having stalls.
Yes, my lord.
Then
He is a catering contractor and
Mhm.
he runs the stalls at Guwahati and Kamakya railway station. And there is my lord wanted to know whether the stalls fall in which category. Guwahati railway station falls in A1 category and Kamakya railway station is at A1A category.
okay. Why do you agree by 8023?
My lord, that is not in terms of the, neither in terms of the catering policy of 2010, which is applicable in my case, nor is in terms of the direction issued by the Supreme Court in SC caterers case, which was confined to the 2010 catering policy, lordship. At page 24, that SC caterers judgment is there. The idea behind the Supreme Court behind renewal, granting renewal, was to allow the considering the economic condition of the country, lordship, and to increase employment. The page
Okay, we'll come
20
back. We'll come back at 2. I think we'll have to hear a little bit. We'll come back at 2. What order did you pass on the last occasion?
My lord wanted to see the
License.
licensing.
Mr. Gupta, what was this?
My lord, actually, as per the terms of the new catering policy 2017, there cannot be further renewals. The lordship has directed to produce the license, but the license is not produced. My lord, what has been read is the tender condition
And master license?
and the pro forma license, my lord, which was a part of the tender. format of the license is what has been read, my lord.
But as 2014 is written there,
My lord.
2014.
Yes, the tender was of 2014, and my lord, that period has expired. The 5 years period has already over.
In 19.
No, my lord, it has been over, my lord.
14 to 5/19.
And further extension of COVID was also given. My lord. The 5-year period from the date of LOA, if we simulate as license agreement has still not been produced.
Okay, well,
Now,
but
from
here-
the date of LOA, it has expired.
You have understood what would be the defense at 2 o'clock.
And thereafter, my lord, on 27/2/2017, the new catering policy of 2017 was enforced, and if I can take my lord to page 102.
Just a minute.
Sorry, my lord.
We lost our notes. You have to just reiterate the facts.
My lord, the petitioner before your lordship is a railway catering
That we know.
contractor, and he pays a statewide GST to that extent. He has his business at Assam, Uttar Pradesh, Maharashtra, Kerala, and Karnataka. We are concerned with the functioning of 3 stalls, my lord.
Yes,
He-
Guwahati and Kamakya, that we know.
Guwahati and Kamakya. And first, my lord, on 29th January 2016, the Honorable Supreme Court, the bench of the Honorable Supreme Court delivered the a judgment in SC caterers. That judgment is has been annexed as Annexure B. Lord.
2016 3SCC, that judgment.
Yes, my lord. Gopala Gaura and our Justice Amitabha Roy. And lord, the operative part, if I can take your lordship to, this was passed considering that the
What is the operative part?
lordship, the operative part is at page 57. Therefore, we have to hold para 27, lordship.
57,
Yes, lordship.
yes.
Therefore, we have to hold that the provision of the catering policy of 2010 are applicable to the concerned respondent. The action of the railways in not granting renewal of licenses to the members of the respondents is arbitrary, unreasonable, unfair, and discriminatory, and the same cannot be allowed to sustain in law. We, however, make it clear only those licenses, ex-para lodge, may be eligible for renewal of their licenses who can declare on affidavit that they do not have the license of more than one shop or kiosk on their name or Benami license at the railway station, with periodical reasonable increase of license. This was, my lord, further clarified by the notification, which your lordship will find at 15/3/2017 notification. Lordship,
One second.
at page 107.
One 107.
Yes, lordship. There, that SC caterer's judgment has been clarified. In pursuance to the judgment of the Honorable Supreme Court on the subject, it has been decided that para 1, lordship, notwithstanding any provision in catering policy 2010 and the earlier catering policies, only those minor static catering static unit licenses would be eligible for renewal of their licenses who can declare on affidavit that they do not have the license of more than one refreshment room at B and below category stations or at one stall at one or one trolley at one kamcha, dala, dhaba, wheelbarrow, handbarrow, tray, table, tea balta at any railway station over. So what was required was that they have to, if they have two licenses, then they have to forego one. Then, my lord, the catering policy, the new catering policy, which my learned friend wants to refer to, was enforced. This was on 27/2/2017.
Page.
Page, my lord, 86, it starts.
'86.
Yes, my lord. If I can take your lordship to the application of the new policy, para 20.2 at page 102. Standards that have been finalized and LOA issued prior to the date of notification of this policy shall be allowed to continue as per policy guideline prevailing at that time. Zonal Railways will cancel all such tenders and return the earnest money to the tenderers in case where LOA has not been issued before the issuance of this circular. So this LOA date of notification of this policy, as page 86 shows, was on 27/2/2017. So, my lord, I am running my static unit since 2010. So this new policy is clearly not applicable to my case, my lord. And then the para 34, where the honorable
You said clause 22 is your savings clause.
Yes, lordship. Then, my lord, para 34 of the SC caterer judgment was further clarified in Vendors Cooperative Society Limited by the Honorable Supreme Court. Annexure F, lordship, at page 108, it starts. Page 109. In effect, this court directed that the licensees who hold more than one license shall be eligible to renewal of one license. Then page 110. This was the direction of
This order is dated?
My lord, the order is dated. '30 October 2018, lord.
Okay.
They clarified this order.
Now what is your problem now?
Now, my lord, I am aggrieved by page the annexure A, the impugned order, that page annexure A, page 23, where they have said that I have to vacate the stall by 31/3/2023. This is to inform you that the license period of catering stalls allotted to you at Guwahati and Kamakya railway station, including the original 5-year license period as well as 10 months extended period granted on account of COVID-19, has already expired as per details given below. This is, my lord, because they are trying to bring in this logic because they are considering that my case falls under the 2017 policy, but 2017 policy itself has clarified that those who are running since prior in point of time, they will not be affected by this policy. Tenderers that have been finalized and LOA issued prior to the
Will
date
it
of-
mean that the new policy will never be applicable to you?
No, my lord, this policy itself says that I am not affected by this
No, that
2017
policy has carved out an exception.
Yes, my lord.
But would it be that at no point of time a new policy will be applicable to you?
Yes, my lord. Then, my lord,
Why, what is the distinction? There has to be a professional nexus to
and
have another class of people, category of people who will fall under the earlier policy, who will fall under new policy.
those who are operating after 2017, they will come under the new policy.
But after expiry of the term, of the license, then
Not expiry, my lord, this 2010 catering policy provides for 5+5.
suppose 10 years is over,
10
license
years.
is over, then you have to get a new license. Can you then insist that I have to be treated to be applying a license under
My
2010
10 years
policy?
period has not yet expired, lord.
When is the 10 years going to expire?
My lord,
It is not 10 years, my lord, it will be page 75. Is the old policy, the 2010 policy, which the petitioner is saying would be applicable. And my lord, that policy provided for
renewal.
first period is for 5 years.
Then 3.
16.1.2, my lord.
Then 3.
Yes.
Then 3.
Yeah, 3.
Then
My lord, it says allotment of all general minor units and at A, B, C category station shall be awarded for a period of 5 years with a provision for renewal after every 3 years.
but DEF for
So-
5 and 5.
My lord.
Turn over the page.
My
This is
lord.
for A, B, and C.
Yes,
For D, E, and F, it's for 5 and 5.
5 years.
D falls under D.
Yes, and some my lord under A also as
Which one?
category also.
Which one? There are three units. One is
General minor unit, lordship.
one is Guwahati railway station. One is Kamakya. Third is Kamakya. So Kamakya, if you have two, at least you have to surrender one, isn't it?
Yes, my lord.
You have surrendered.
Yes, I have only one. Kamakya.
No, there are two. Platform 1 and platform 2 and 3. If you come to the order at 23,
Yes, my lord.
you are Rajendra Kumar Mangla, isn't it?
Yes, my lord.
You have one at platform number 1, Guwahati railway station.
Yes, my,
Number 2, platform number 1, Kamakya railway station.
yes, my lord.
Number 3 as platform number 2 and 3, Kamakya railway station.
Yes, my,
So Kamakya, you have 2. The benefit is given only when you have 1. And the next judgment says that if you have more than 1, you have to forfeit 1. So 1 you can at least run by the earlier policy.
My lord, that
Anything?
judgment is not applicable, my lord. The judgment of the apex court was in the context of 2010 policy. It has upheld the 2010 policy. And the clarification note which has been read, my lord, that is in a different context. It is not in relation to
What about
2017.
the first judgment, SC caterers?
Yes, my lord, that is the judgment, my lord. If I-
No, SC caterers is here, appended
SC
here.
caterers, my lord, that was, my lord, in respect of
If you come to
my lord, licenses which were granted to respondents prior to creation of IRCTC in 2005. The facts of that case was, my lord, in respect of licenses in favor of members of the respondents prior to the creation of the IRCTC. And my lord, we'll see if I can place the judgment. The relevant facts of the judgment are at paragraph 2 and 3. So catering policy 2017 was not before the apex court. At
Yes,
that point
it was
of time,
not
it
there.
was 2010 and my lord prior to 2005. And after 2017, my lord, very categorically, it is provided in the policy that there can be no further renewal if the term has expired. And here the term has expired, my lord. And there is no application for renewal also. And in fact, my lord, they have not annexed the licenses also from where we can count the date. But if we count the date from the issue of LOA also, then also, my lord, the period of 5 years had already expired. No, that judgment was completely in a different perspective, my lord, because
But see,
2017 policy.
if you read the facts of SC catering,
My lord,
come to page 24
my lord,
of the paper book,
my lord,
third para.
my lord.
Appeal arises out of judgment dated 12/9/13 passed by the High Court of Andhra in WS so-and-so, whereby the division bench of the High Court upheld the order of the single judge. When
Under
it
the
has been held
catering
that the
policy-
respondents are entitled to get
My lord,
their license renewed under the catering policy of 2010.
my lord.
Now, this appeal before the Honorable Supreme Court was by you, by the
Yes,
railways, isn't
my
it?
lord.
What was the final outcome?
My lord, the policy was upheld
my lord, only liberty was given, my lord, to those licensees who, my lord, if I may read, if we may make however clear that only those licenses may be eligible for renewal of their licenses who can declare on affidavit that they do not have license of more than one shop or kiosk in their name or Benami license at the railway station with periodical reasonable increase of license. That is a person to 2010, my lord.
Yes.
Not 2017,
No, no, you, before you read 28, you read 27 also.
my lord.
Therefore, we have to hold that the provisions of the catering policy 2010 are applicable to the concerned respondents.
My lord.
The action of the railways in not granting railways. Now, here is a respondent, here is a party
Yes,
whose initial licenses prior to this.
yes, yes, my lord.
Okay.
My lord.
Now, 2010 will be applicable.
My lord.
The only requirement is that if they have more than one, they have to declare on affidavit.
Yes,
Now, from the notification, we find that so far as Kamakha is there, they have got more than one stall.
Also, there has to be an application for renewal. There is no application for renewal. The term of 5 years under the old policy had already expired. Because, my lord, in the additional affidavit, although the original license has not been annexed to, my lord, but the master license agreement at page 200, if my lord will
There's
see,
2014.
that requires that, my lord, renewal will not be a matter of right. Licensee must apply for renewal minimum 6 months in advance before the expiry of the contract. So
Now they are running presently, you have given a notice for to vacate. They're running on the strength of what?
2010 policy, my lord, the period
No,
of,
policy, where is the license?
no, they have not annexed the license.
You have allowed them to run
My lord.
this impugned order.
My
at
lord, the
least
impugned order,
23.
if I may read, my lord, it clearly states, my lord,
Have you
my lord,
termed them to be trespassers?
no, my lord, we have categorically stated, if I may read the impugned order, my lord, at page 23 again. My lord, this is to inform you that the license period for the catering stalls allotted to you at Guwahati and Kamakya railway station, including the original 5 years license period, as well as 10 months extended period granted on account of COVID-19 had already expired. So, my lord,
Now, C says that C falls under D. D has an expiry period of 10 plus 5 plus 5. So it's 10
no, my
years.
5 plus 5 is nowhere there, my lord.
No, you have just read that
And my lord,
2022.
My lord, there is no 5 plus 5, it is 5 plus 3. That also, my lord.
No, 5 plus 3 is ABC.
My lord, the page 75, my lord will take is the 2010 policy.
Yes.
My lord,
5 plus
16,
3 is
my lord.
ABC.
Tenure, yes.
Allotment of all general minor units at A, B, and C category stations shall be awarded for a period of 5 with a provision for 3 years extension. Correct?
My lord.
Now, turn over the page.
My lord.
Allotment of, say, similarly for allotment of all general minor units at D, E, and F category stations will be for 5 with a provision renewal of another 5 years.
My lord, these all are A categories, my lord. Just now it was submitted.
No, that day it
All
was
are under
D
A categories. My lord, in the first half, the submission was made that they all fall under category A.
Madam? You had said D.
Category A. A category.
If it's A, it's 5
A1
plus
and
3
A
only.
category, my lord. A1 and A category.
There is no A1 category. This is A,
Not
B,
it
and
will
C.
be A, my lord.
A, B, and C, D, and F.
My lord, A category, my lord.
No, are you
A general minor unit, lordship.
making this submission on instructions or just in the air?
No, my lord. My lord, it was submission made by the petitioner.
Yes, she said D.
My lord, A, she is, my lord. To A category, no? That is why, my lord, the license, with the copy of the original license ought to have been annexed, my lord. What is annexed is the tender conditions. And my lord, that is why, my lord, the last.
From where do you get an A or D?
I,
Anywhere from the anything in this petition?
My lord, I am a general minor unit.
Now, these are both
No
general
category.
minor units. If you come to paragraph 75, page 75,
Yes, my.
general minor units are categorized into 2 parts. A, B, C, 1 part, D, F, another part. For D and F, your renewal is for another 5 years. For A, B, C, renewal is for 3 years.
5 years, then I am. My lord, allotment of all general minor units at A, B, and C category stations shall be awarded for a period of 5 years. 5 years starting from 2014. with a provision for renewal after every 3 years.
Hmm.
Every 3 years, the renewal will be done on satisfactory performance and payment
Yes.
of all dues and withdrawal of court cases. So my lord, and after SC caterers, judgment and vendors catering, towards, with regard to general minor unit, Railway Board has already issued a circular on 2019, Lordship.
Madam, the meaning is not that. The allotment is for 5 years for A, B, and C,
Yes,
and
Lord.
after expiry of 3 years, if you have satisfactorily performed, then it will be renewed for the entire period of 5 years.
Yes, ma'am.
And for D and F, that let us read for D and F, for a period of 5 with a provision for renewal after every 5 years for a period of 5 years on satisfactory performance of D. Only for D and F, there is a provision for extension. For ABC, there is no provision for
I just
extension.
confirm, my lord, it is A category, my lord. Just now, I've taken a confirmation, my lord, it is, they.
ABC, there is no extension. ABC shall be awarded for a period of 5 years with a provision of renewal after every 3 years on
Yes, ma'am.
satisfactory provision
Performance.
performance. After 3 years, they have an appraisal. If you are performing satisfactorily, then it will be allowed extension for the entire period of 5 years.
Would- Had there been an application for renewal, my lord, prior to the coming into force of
I
the
think
new
we
policy?
need some more input from you, some more document from you.
And my lord, Railway Board has already granted extension to the minor static units. Your lordship will get that at page 125. 125. 126, lordship.
Word
There is
is,
There is a Delhi, reference has been made to a Delhi High Court judgment, lordship.
word is,
Minor static unit.
They are prior to the policy.
here,
Railways are advised to maintain status quo. Maintenance of minor static unit. And my lord, for the catering stall at Nagpur station of this particular petitioner, the competent authority has already accepted the renewal request, 16/3/22. That your lordship will find at page 132. Also, my lord, aggrieved by such an order, this petitioner had approached the Kerala High Court, and Kerala High Court has already granted status quo order. Lordship will find that at page 141. 145, lordship.
Hmm.
141, 143, 145.
132 is the petitioner yourself.
Yes, lordship.
Yes, how, what is the nature of this stall? Same, similar.
Yes, my lord. And further coercive steps, including the closure of general minor catering stall, hearing number MAQ 099 at platform number 1 at Mangalore Central Railway Station.
So Gupta, you seek instructions.
My lord.
And maintain status quo, 2 weeks. If the Nagpur case is different, you can immediately get the instruction. But petitioner is the same. So minor catering.
Lord, so there are similar judgments, my lord, I have placed, my lord, where it has been rejected, my lord, the prayer for pension, praying for renewal. I may place 2 judgments, my lord, of the Telangana High Court and Patna High Court. Yeah.
You get the instructions. Heard MSP Chaudhary, learned counsel for the petitioner, who is aggrieved by the contents of a communication dated 2/3/2023 issued to the petitioner, whereby the petitioner has been directed to vacate from the concerned railway stations wherein they have stalls. Full stop. It is the case of the petitioner that certain benefits have accrued upon the petitioner in the form of a judgment of the Honorable Supreme Court dated 29/1/2016, reported in 2016, 3 SCC, 582, I'm to do the SC caterers, page 24. The said judgment has been further clarified, further reiterated and clarified by another judgment of the Honorable Supreme Court dated 30/8, 2018, page 109. The Learned Counsel submits that in view of the benefits, the impugned order is not sustainable, full stop, para. On the other hand, Sri H. Gupta, Learned Counsel for the Learned CGC, appearing for the railways, has submitted that the license of the petitioner has long expired, and therefore the order has been issued, which is in accordance with law. Full stop, para. Issue notice returnable on. Fix the date, Mr. Gupta.
My lord.
On on 25th of
My lord.
April.
My lord.
Is it okay? Or you have 21st of April also?
We can take it on 21st.
Huh?
25th.
25th will be.
25th, 24th is a holiday.
No.
25th. That Sri H. Gupta. And the CGC accept notice on behalf of all the respondents. Or is there CGC? Is there or what?
All the respondents.
All the respondents. Let extra copies of the petition be served upon him by tomorrow. Sarah, heard the Learned Counsel on the interim prayer. MS Sri MS Chaudhary, the Learned Counsel for the petitioner, has also referred to certain other judgments pertaining to the petitioner, wherein its interest has been temporarily protected. After hearing, it is directed that status quo be maintained so far as status quo with regard to the impugned order be maintained so far as the petitioner is concerned.
Only petitioner, my lord.
Oh, yes, what is the since this order of status quo has been passed on the motion stage, the same shall be reconsidered after obtaining more instructions by the Learned Railway Council. Yes. Willful, yes. Take on. It will now. Yes, what is this? Yes, government. Sharma, what is this? PNRD is there. Name sure or not? Not sure. PNRD. Anyone from the Panchayat Rural Development Department? Would have it on Wednesday. We'd ask them to reflect the names, okay? Registry to list this case for motion on Wednesday, on 29th of March by reflecting the name of Standing Council, PNRD Department. Please inform the Standing Council.
This is that matter for
Malt.
products.
Yes.
And pursuant to your lordship's, my lord, interim order that was passed, we have, my client has, my lord, filed their e-tender, and that has been, accepted through e-process, my lord. Here is the receipt of the, if your lordship.
Yes, what is the instruction?
My lord,
Yes, what is there?
My lord, lordship may kindly see the first paragraph.
Yes.
Then your lordship may skip to, my lord, second page, last paragraph, my lord, during emergency situation. my lord.
This is the only reason.
My lord.
You bind them. You have a clause.
Clauses has been incorporated as
You
per
bind
instruction,
them.
my lord.
That you have to see for this situations like this, which is extraordinary in nature, force measure. Nobody can work. It's not that somebody is outside the state
My lord,
cannot come.
first of all, my lord, as per instruction, my lord, that as per the CBC guidelines, my lord, that my lord, condition has been stipulated in the NIT, my lord. Secondly, my lord, past, my lord, performance and the situations and the local, my lord, registration is insisted on the because of this region stated in the instructions. And
You want
apart
the,
from
you
that,
want
your
a job,
lordship,
you want to be job to be done. You are not interested in who is registered here or not. You want a job to be done smoothly, isn't it?
yes, my lord.
You bind them, you say that you have to have a go down here, office here.
And apart from that, your
One
lordship,
can have a registered office anywhere, but they can function somewhere else also.
apart from that, your lordship may kindly see
And
the,
your entire first page is yours, is against you.
my lord, they stated, my lord, as per the CBT guidelines.
No,
my lord.
we appreciate what he has written. He stated what is fair.
And in fact, lordship may kindly see who is the petitioner. Petitioner is the manufacturer. Your lordship may kindly see the clause, page 55
Of the repetition.
of the writ petition.
Yes, please. 5-5.
By the qualification criteria for bidders.
Yes.
My lord, lordship may kindly see the second one. The bidder must submit copies of their up-to-date trade licenses from the competent authority. The bidder should have their registered office in the state of Assam, and they must have their trade license registration in Assam before the date of 31st March 2019. Your lordship may kindly skip to second page, page 56. The qualification criteria for the bidders. First qualification criteria for the, my lord, authorized dealer, supplier, OEM supply, etc., not for the manufacturers.
No, when you want the bidders, manufacturer also to submit certain statements, why not the manufacturer themselves directly?
Lordship may kindly
Number
see-
one. Number two, what is the rational nexus you're trying to achieve
Well,
or having between a bidder who has its registered office at Assam with the object which you seek to fulfill?
My lord, this
There
is,
has to be some connection
my lord.
that this is the nature of work. You have to have an office, registered office at Assam because of this reason. What is the reason?
My lord, this is.
You are concerned with malt-based supply of food in the Anganwadi centers. Whether they have a registered officer Assam or not, it's how does it matter?
Lordship,
And when the work is of huge quantity.
this clause is not for the manufacturer. My lord, lordship may kindly see the first one.
Yes.
This invitation for bids is open to authorized dealer,
Yes.
supplier, OEM, for supply of malt-based food.
Exactly. That is the reason
Yes,
where
lordship, if
that
you
is
are
the
lordship-
reason we're asking the second question.
My lord,
You have given the invitation to whom? Authorized dealers,
my lord,
suppliers, OEM.
my lord,
Now, if you come to the next page,
my lord.
qualification criteria for the
For
bidders, manufacturer.
Manufacturers.
You need the criteria of the manufacturer also. Does it sound logical?
Manufacturer may not be, my lord, registered office, or manufacturer may not belongs to the state.
So
of
if the
Assam.
manufacturer wants to supply,
My lord, then if you're manufacturer, then my lord, through the dealers. Manufacturer may, and see, lordship may kindly see the criteria 1, 2, and 3 of the manufacturer. 3 also, my lord. 3 also. my
that is it. You need details of the manufacturer. You don't want manufacturer to come to us. Why do
Manufacturer
you want a
may
middleman?
also come, my
You are
lord.
a manufacturer.
Manufacturer only. No,
Yeah.
no, my lord, dealer or my lord, supplier has come before this
You
court,
want
my lord. And-
the person directly has come to you.
And the
You should
clause,
be happy.
the clause which is, my lord, for the supplier and dealers, that has been challenged by the manufacturer. Lordship may see the prayer person.
He is not challenged. He wants to participate. You have put him out.
My lord, the clause is challenged, my lord. That clause, which is, my lord, made for my lord supplier and dealers, that has been, my lord, challenged by the manufacturer.
Which
Lordship,
clause?
Page 17, my
The
lord,
turnover clause.
page 17. Page 16, sorry, my lord, 16. It's from 16. First one, my lord. First one is not made for manufacturer, and petitioner is a manufacturer, not a supplier. He's not come within the purview of the,
Manufacturer cannot be a supplier.
maybe, my lord, but that clause.
Where is the distinction?
Distinction,
If
my
the
lord.
manufacturer wants to supply, he becomes a supplier.
He
He may not
may-
be a dealer. You may
My lord.
be correct. He may not be a dealer.
He may not be a dealer. And my lord, first clause is, my lord, page 76. That is made for, my lord, dealers only. Not for the, my lord, manufacturer.
challenge that I cannot participate.
70? 70? Page 76.
Page 76, my lord, 56, my lord. Sorry, my lord, 55.
55.
Unless I challenge it, my lord, I cannot be a supplier. I cannot be a, my lord.
This is, my lord, this is, my lord, qualification criteria for.
No,
bidders.
see, this invitation of bids is open to an authorized dealer supplier.
My lord.
He wants a manufacturer wants to supply.
I am also supplier. As simple as that.
I don't think it's that difficult.
But no supplier, no authorized dealer come before this honorable court.
He supplies, he wants to supply.
Only thing, my lord, we have insisted
You,
to
you,
registered
you,
officer.
you open the bids. Don't insist on this condition. Open the bids, financial bids. Put in a still cover. If he's out in financially, matter ends there. If he has a case in financially, then we'll adjudicate. I think interest will be served, both of you. We don't want to delay the matter.
This is, my lord, urgent, sir, my lord.
We don't want to delay the matter.
There is also, my lord, my lord, product, requirement of product in.
Yes, heard
urgent nature.
Sri M.K. Chaudhary, Lansina Concept, assisted by Sri M. Sharma. Also heard Sri D.K. Sharma, Learned Additional Senior Government Advocate, Assam. Matter, para. This matter was considered on 24/3/2023, when this court, after recording the basic facts, had directed the learned State Council to obtain instructions. This court had also directed that to balance the equities and as an interim measure, the petitioner be allowed to submit its bid pursuant to the NIT in question. Full stop. The Chaudhary, the senior counsel, has submitted that pursuant to the aforesaid order, the petitioner has indeed submitted its bid, which has been accepted.
Accepted by the e-portal.
Is said by the e-portal. Full stop.
Pursuant to the interim order.
Huh?
Pursuant to the
Pursuant
interim.
to- para
We have
three-
also, my lord,
three-
provided a sample of the, my lord, the sample bottle has also
of
box of the products that has a,
you have
we have got our own products.
we haven't seen.
My lord, they have seen, my lord, it will be there. Or we can bring some boxes here, my 5 kg.
Not for us, for the bar.
And-
What is it? Bonvita?
No, my lord, the trade name is Provita. Provita.
Is it something actually edible or something?
It is as good as my lord Bonvita or my lord Complan or
You are from which place?
from
Haryana.
Haryana. Office in Delhi.
Office in Delhi? Then we have doubts.
We'll supply some products, my lord, for the bar. We can worship that.
It may be Delhi ka laddu.
Temple and my lord, the supply is very much difficult to identify.
The learned government advocate has raised a contention that the bids were invited from authorized dealers, suppliers, authorized dealers oblique supplier oblique OEM, and admittedly the petitioner herein is neither of the three, and therefore not entitled to make a challenge on behalf of the bidders. Full stop. The aforesaid position, however, has been refuted by the senior counsel for the petitioner by contending that though the petitioner is a manufacturer, it can also play the role of a supplier. And in any case, a bid cannot be restricted. A bid of the present magnitude cannot be restricted only certain categories, which would be against the spirit of maintaining fairness and transparency in the distribution of state largesse. Full stop, para. Let notice be issued, returnable on. Tell us a date.
After vacation, my lord? Or
No, if you want before vacation.
before vacation,
Because we'll give you time to open the bids.
my lord.
You give the date later on. Listen to the order first. So and so. In the meantime, sorry. You accept for whom? Both.
Both, my lord.
Sri Sharma, the learned edition, Sri to accept notice on behalf of both the respondents. Let extra copy be served upon him. Full stop. Para. In continuation with the earlier interim direction, since this court has been informed that the petitioner's bid has been accepted through the e-portal, it is directed, it is observed. It is directed that the bid of the respective parties be opened and the financial bids of the parties be opened and the same be kept in a seal cover to be produced before this court. Full stop. It is further clarified that the bid of the petitioner shall not be rejected on the ground on which the present challenge has been projected.
As a interim measure. As a interim.
As an interim only.
Lordship may fix it on
Now give the date.
4th of April, man.
Don't give the date.
Then my lord, this week only, my lord, up
You can
to
have it on 3rd or 10th.
10th.
4th, I think we can. 5th, there'll be a problem. 4th to 3rd,
I may not be available.
then 10th. 10th.
File an affidavit,
I'll try.
otherwise it's difficult to.
If you're out on financial, then you're out.
Yes.
Obliged.
এটা লিখিব, huh? এটা লিখিব। Sri Sharma has also placed before this court certain written instructions, according to which the only difficulty projected is that during emergency situation, comma, if the bidder is located outside the state, comma, their response has been found to be lukewarm. Yes, next. Yes, anything?
My lord, my learned friend.
My lord, in fact, as per the civil engineer, my lord, they are saying that, my lord, they are, my lord, helpless, my lord, they cannot accept it now. It has been cancelled, the tender has been issued, which has been kept in abeyance, but they have already taken a leave. Because enough time was.
He's
given.
abiding by whatever you had wanted.
So we are paying, my lord.
That is
only
whatever
with
you had
some
wanted.
delay.
That's what.
Only of
Only in respect of one work, 3 we are giving up. Here, my lord, because I was asked to start the work which I did. I've spent some money, about 10% work I have done. That's why.
We don't want to stay anything
Ah.
at this stage. Why don't you reconsider?
Some direction may be given indicating this part that, my lord, he has already
That they
executed.
will consider, my lord.
Dispose
Yes,
this.
ma'am.
Heard Sri K. Chaudhary and Senior Counsel, assisted by Sri R.M. Dekar, also heard Sri B. Gogoi and Standing Counsel, PWD, full stop. Considering the nature of the grievance and as agreed to by the parties, comma, but again, your representation will be rejected again.
No, representation was for different purpose. There have
And
been-
if we ask your consideration, rejection, and again,
possibly, my lord, if your lordship gives them a direction to consider, they might all. Henceforth, we are not coming back. This, Lord.
no, we also don't want you,
Yes,
our
yes.
citizen
No,
to
only
come
thing
again
is,
and again.
having regard to the peculiar fact, in the other 4 writ petitions, I am not pressing, my lord.
Other
Item
other
36.
three.
Yes, other
4, my lord.
4, my lord.
There are 5 in total.
Yes, today, no, my lord, there are actually 4 cases. Out of the 4, I want to pay now in respect of 1.
The other 3 you are not considering.
No, in fact, 4. In this case also, there is a petition in the earlier round which has been in list today.
Yes.
Item 37
36 to
to
39.
36 to 39. That lordship can close in view of this order.
Okay. Number 2. And as agreed to by the parties, comma, this writ petition is taken up for disposal at the motion stage itself. Please have a seat. The present petition has a checkered history. Full stop. Initially, the petitioner had approached the court challenging the requirement to submit additional performance security. Full stop. The petitioner was unsuccessful in the said challenge, which was also affirmed by the division bench.
Yes.
Said challenge and the dismissal of the writ petition was also affirmed by the division bench. Full stop. Thereafter, the petitioner had approached the authorities with a prayer to adjust its entitlement from the same department towards the head of additional performance security. Full stop. The said approach was also rejected, for which the present case has been filed. Full stop. The senior counsel for the petitioner has submitted that the present case pertains to only one of the 4 packages in which the petitioner is ready and willing to pay the additional performance security, which however has not been accepted on the ground that the authorities in question, namely the PWD, has gone for a retendering of the process. Full stop. Para. This court.
One more thing, my lord. Para 13, we have stated that pursuant to verbal instruction, we have done 10% of the.
Okay. It is also the contention of the petitioner that before such retendering, the petitioner had initiated the work and had claimed to have done about 10%. Full stop. Para. This court, by the earlier order dated 24/3/2023, after observing the background, had directed the Gogoi, the learned standing council PWD, to obtain instructions, and also directed this matter to be listed along with the other writ petitions which are to be listed, which were to be listed today, and in fact have been listed. Puts the para. The standing council PWD, however, has informed this court that the department is not in a position to accept the offer, as the work in question has already been given for retendering. Puts the para. This court has given its NCS thought to the facts and circumstances. Full stop. The petitioner had raised the grievance and the issue, on the issue of requirement of additional performance security in the works on certain grounds, which however has not been accepted by this court. Thereafter, though there has been other developments, in this case, the petitioner has submitted, has expressed his willingness to make the said deposit, which has been rejected only on the ground that the work that the work in question has been retendered. Full stop. Though the rejection by the authorities per se does not appear to be wholly unreasonable, as the work has already been put to retender, considering the peculiar facts and circumstances, this court, in exercise of its equitable jurisdiction, as an exceptional case, directs the authorities in question, namely the Chief Engineer, Public Works Department, Border Roads, to reconsider the offer made by the petitioner regarding his willingness to pay the entire amount of the additional performance security only for the work in question, namely package number AS 17260, correct?
Fine.
The petitioner, the counsel for the petitioner has also made a submission that has also considered that the offer made is only in respect of the said work, and for the other 3 works, he is not in a position to make such offer. Full stop. Sarah, under with those observation, comma, the instant writ petition is disposed of. The consideration directed to be made, the reconsideration directed to be made may be done expeditiously and preferably within 2 weeks from
7 days. Madam.
within a period of 10 days from today.
Right.
Full stop. It is further directed that till such decision is arrived at and communicated, comma, no steps be taken for in the process of retendering of
For
the
this
job in
petition.
question.
For this
Of the
particular.
job in question.
Civil border roads.
Border.
Respondent number 2. Respondent number 2.
Oh, we have said border roads.
Yes.
We should do. We should. Border.
Deep level.
Mr. Chaudhary, the other.
Oh, sorry, other four can be closed. Item 36, 37, 38, 39.
In view of the orders passed
We are not pressing that.
in WPC 1725/2023 filed by the same petitioner, comma, the London Senior Counsel for the petitioner submits that he would not press these writ petitioner, THES here. Also heard speak who standing considerability who stop. The writ petitions accordingly stands closed.
But there is an interim that may be vacated.
Interim order passed earlier stands vacated.
I'm obliged.
Oh. আর এটা থেকে আপগ্রেড করবো খুঁজছিল কি নাম দিয়েছেন কি আছে পাচ্ছিল না হ্যাঁ কোনটো আইটেম নাম্বার
Before my learned friend starts, I was directed to give a status report. If today I have been informed by the IO that supplement complaint with respect to the present petition was also filed.
Supplementary charge sheet.
Charge sheet loss. Complaint, we are filing complaint. That is not on record, neither filed by my friend, none I have been provided by the IO.
Are you aware of this?
No, it was not supplied to the petitioner when the.
You'll be entitled to a copy, I think. You'll be entitled to a copy, I think. It has to be supplied to,
Yes,
isn't
but
it?
Supplied if they rely on. Because my case is there something different, Lordship, because my case is that he is a license holder. So whether that supplementary case, such a complaint will be required.
Lordship, with respect to the petition was happened, he was arrested by Bisney police station, Lordship. And after coming to know about that, he was.
Okay, we'll give you a short date. There's no issue. When can you come back?
Lordship on Friday.
Friday, miss? SC Kyle, Leonard. CGST.
Standing counsel NCB.
Sorry, standing on the NCB submits that as per information, as per instructions received, comma, a supplementary complaint has been filed. Full stop. He, however, prays for some more time to get the details, public copy of the same. Full stop. The Ahmed, the London Counsel for the petitioner, may also take instructions in this regard. Full stop. Para. List on?
Yes, Friday.
Friday.
Much of.
31.
Mention করেছিল Ms. Burwa, something was mentioned in the morning. করেছিল না এটা? P. Burwa, R. Burwa. Oh.
That case, I appeared for the petitioner. They mentioned.
Some case, কোনটো আছিলে? 40?
পদ্মিনী হাতে কিবা মেনশন কৰিছিলে নেকি?
Where are they? They had mentioned this matter.
Yes, yes, they may be.
Hmm?
Private party goes.
Let them come then.
Okay,
You're here otherwise.
yes, sir.
Yes, Mr. Rato.
Lordship, this is the contractor matters admitted bill amount in respect of year 2014, Lordship. If they have filed an affidavit admitting their affidavit paragraph 10, Lordship. Numerous communication has been made. The SP said that the fund is not made available there, in spite of repeated. Affidavit filed by respondent number 3, Lord.
Which paragraph?
Paragraph 10, Lord.
Yes.
His affidavit is by superintendent of the police, right? And she has admitted and she has written to the higher.
And 13th attempt till 2021. Amount is also very small one. It is 2,10,600.
Heard the you, Dr. Current Counsel, for the petitioner who has filed this petition for release of certain dues which the petitioner claims to be entitled to in respect of works done. For during the parliamentary election of 2014, full stop. The amount in question is rupees 1,05,300.
Lordship, 2 orders. Each one.
Hmm?
Total in total 2,10,600. Two orders.
For two of each for 2 votes.
Yes.
Full stop. The learned counsel for the petitioner, the doctor has submitted that the entitlement has been admitted by the respondent in the affidavit filed on 2/3/2022. Full stop. Para. The BJ Tarudar and senior counsel representing all the respondents submits that the affidavit which has been referred to above would make it clear that the amount in question has not been able to be paid to the petitioner due to lack of funds. And in this connection, a number of communication has been written by the said respondent number 3 to the authorities in question, full stop. Para. For any reference, comma, the relevant readings made in paragraph 10 of the affidavit in opposition dated 3/2/2022 is extracted herein below. Page 38, Keratin. Para. After perusal of the said averments, comma, it is clear that the amount in question is not disputed, and the reason which has been shown is only lack of funds. Full stop. Para. The aforesaid reason of lack of funds cannot be a perennial one, as it is the duty of the respondent authorities to arrange for the funds for works done, that too during an emergent situation for holding the parliamentary elections of the year 2014. 14. Para. In view of the above, the instant writ petition stands closed by directing the respondent authorities to clear the amount in question, namely rupees
210,600. 2,10,000.
210,600 to the petitioner expeditiously and preferably within an outer limit of 3 months from the date of receipt of certified copy of the order. Yes.
Obliged.
You pray for upgradation, you are not here. You pray for upgradation, you are not here.
Lordship, that time Lordship had not allowed that.
We did not say, we said we'll see. You should be vigilant. We said that if you finish the motion, we'll see. Yes, what is it?
Kindly take up.
What is the urgency?
Lordship, the urgency is that Lordship, the tender work is complete. Almost 210 days have passed. Lordship, we have not received the payment because of an interim order which said that Lordship, any further action may be taken with the leave of the court, Lordship.
You have done the work.
Lordship, we have done the court.
What was the work? Supply.
Supply of notebooks.
Supply of textbook.
Lordship, in fact, the session will also come.
How much is the amount involved?
Lordship.
How much is the amount involved?
Lordship, in there are three WPCs, Lordship. 6 crores each in WPC 1877 and 1878, and about 12 to 14 crores in WPC 1876. Lordship.
6 in?
6 in WPC 1877 of 2022.
6 in?
And also about 6 crores in 1878.
22
Or
and?
22 and around 1876.
Almost double.
Lordship.
This is almost 24 crores.
Lordship, around 27.
This is 6, 6 and 12.
Lordship, 24.
24. What do you say?
My lord,
Only on this, only on this. We are not deciding the main matter.
that's why, my lord, no, the idea was to, that is why, my lord, it was said, because they have taken the chance. We made out a case, that's why that order was passed. My lord, will kindly see how we have been, how our technical bill was rejected. My lord, they
Just
want.
the interim order.
Yes. এখনো পাঠিয়ে দিয়ে আসছে।
Why division? Why there is a division bench?
We approach the division bench against refusal of interim order.
Thereafter,
they have proceeded. In any case, the learned single judge also said, my lord, that whatever action they take will be subject to the outcome of the case. Interim order by the single judge was, it is however observed that further action taken pursuant to NIT dated 17/1/22 would be subject to final outcome of the writ. Then page 22, my lord. For ends of justice, we also direct till disposal of the writ petitions and without leave of the court, the state respondents, including Ahom Hormoikha Vision, shall not release any payment to the concerned suppliers.
or this is the division bench?
Yes. Our single judge, after hearing the party, shall dispose of WPC number at an early date.
Total disposal of the petitions. We cannot tinker with this now.
First, you will have to hear the matter.
Yes. Are you ready for hearing? Because division bench, otherwise we have said we wanted to say something. Not full payment, maybe some payment. But division bench has said that don't touch till the disposal of the petition.
In
If
fact,
you're
when
ready and
I
ready for,
was filed, Lordship, we were done with about 90% of the work. And in the meantime, Lordship, 100% of the work in all the 3 writ petitions have been completed.
no, if you see the observation of the Honorable Division Bench, third paragraph from the, before the end. For the end of justice, we also direct that till the disposal of the writ petition so and so, so and so, so and so, and without the leave of this court,
Lordship.
the state respondent, including the Ahom Hikha, shall not release any amount to the concerned supplier. It's a positive direction, restriction. So and so. However, Learned Single Judge, after hearing the parties, shall dispose of so and so at an early date. If you're ready with the hearing, we can go for the hearing. Unless we hear and dismiss the petition, then it will be difficult. Which one would you like to take first?
1877.
7-7.
Yes. Very, it'll hardly take 10 minutes, my lord.
Madam will not adjourn the matter to think over.
My lord will kindly come to page 59, my lord.
1877.
Yes.
59.
Yes. This is the NIT, my lord. Mission Director, Ahom Horbahikta Abhijan Mission, Kahilipara, Guwahati invites tender from reputed exercise book manufacturer to e-tendering process for supply of evaluation and practice book for supply, the item listed below to be distributed amongst the students of class 6 to 8 of elementary school. Bidder must have an average annual turnover of minimum 1.37 crore during the last 3 financial year, that is 18-19, 19-20, 2021 only. The bidder can submit CS certificate for the year if the audit reports are not ready. Kindly see, my lord, what is the quantity required is in total of these 4, my lord, it is only 26,21,905. If we add up all these 4 figure, my lord, it comes to 26 lakhs.
Books, number of books.
Yes, one need to have experience of this much. Now, my lord will kindly come to page 63. This is the clause which, according to my lord, the tendering authority, which we did not fulfill, which is absolutely incorrect.
Page
63, my lord. 11.2.
63.
Towards the bottom, 11.2. The documentary evidence of the bidder's qualification to perform the contract, if its bid is accepted, shall establish to the purchaser's satisfaction that the bidder offering to supply goods has the minimum capacity of supplying similar quantity or more with the specified time limit in the NIT. A certificate duly authenticated by the competent authority, as for example, a gazetted officer of the industry, for certifying the documentary evidence of the area where bidder is located, showing the production and supply capacity for the last 3 financial year. That means, my lord, a certificate regarding their capacity to supply the quantity mentioned at page 59 should be issued by a competent authority. That's a gazetted officer of industry for that particular area. Then, my lord will kindly come to next page. That the bidder has minimum average annual turnover of minimum 1.37 crore during the last 3 years, that is 18-19, 19-20, 2020. So these are the requirements. If a lordship would kindly come to page 66, my lord. Clause 16.1. During evaluation of bids, the purchaser may at his discretion ask the bidder for a clarification of its bid.
Number?
16.1 at page 66. During evaluation of the bids, the purchaser may at his discretion ask the bidder for a clarification of his bid. Request for clarification and response shall be in writing, and no change in price or substance of the bid shall be not offered or permitted. That means, my lord, there is a scope for seeking any clarification. Of course, that should not include change in price or substance of the bid. Then my lord will kindly come to page number 107. My lord, this is my capacity certificate. This is to certify that JC Stationery Private Limited, that the petitioner bearing Uddog Aadhaar number so and so, Andhra Pradesh, is engaged in the line of activity manufacturing notebook and other stationery installed production capacity of the unit is 50,000 MT per annum. And my lord, kindly see the quantity we supplied was 2018 30 crore 5,60,309. Then my lord, 1920 30 crore 661 lakhs 47,753. 2021 31 lakhs and crore 22 lakhs, etc. So as against the requirement of 26 lakhs, we have capacity of supplying 30 crore copies. Then my lord will kindly come to page number 100. Or before that, my lord will kindly come to my bidding capacity. Sorry, but the financial part, my lord. Please come to page 24.
Page
24. My financial capability should be of 1.37 crore. Proceedings of Director of Social Welfare, AP Amravati, Present so and so. 38/2018. Government hostel supply of notebooks to social welfare hostel boarders for their 1819 payment 4 crore 93 lakhs 80,000 and odd. So as against my lord 1.37 crore in 1819, I have made supply of 4.93 crore. Then my lord will kindly come to page number 50. For 1920, my lord, a supply of notebook institution academic year 2019-2020, it is 7 crore 22 lakhs and odd. Page 50, my lord. So for my lord, 1920, it was 7.22 crore. Then my lord, for 2021 at page 29. Kindly see, my lord. It is 75 crore 76 lakhs 10,000. So my lord, I meet both the qualifying criteria. One, instead of 1.37, I have more than my lord that. And as against requirement of 26 lakhs, I have experience of supplying 30 crores each year. Now my lord will kindly come to the impugned minutes at page 100. Page 100. This is the impugned minutes, my lord. Serial number 3 is the petitioner, JC Stationery Private Limited, Andhra Pradesh.
The state level purchase committee has examined the documents and evaluation statement. After scrutiny and verification of the evaluation statement evaluated by evaluation committee, SLPC observed that the bidder has uploaded the information on past supply from government department for 2 years and one from private submitted certificate of completion of delivery from private organization instead of government, semi-government, bank solvency certificate in favor of project director Vijay Vara. Now, my lord, what had happened for the year, my lord, 1920, in addition to the government, I also supplied to the ITC. That they have taken note of, but they have not taken off the page, my lord, 50, which I have shown, my lord. Now, for that, if your lordship would kindly come to page 57. This document they are taking note of, but they are not taking note of the document at, my lord, 50 and 29. Sorry, for 50. Kindly see, my lord. This is by ITC. This is with reference to the manufacturing agreement for execution of work order entered into with JC Stationery Private Limited and as renewal from time to time. We hereby confirm the following. Mr. JC Stationery Private Limited has successfully manufactured and executed the following order and supplied to ITC for the year 1920. These notebooks were supplied to us including institution. Summary of the year 1920. Number of books 8 crore 34,000 lakhs and odd, and value is 17 crore 99 lakhs and odd. So, my lord, this they have taken note of, whereas the one at page 750 they have ignored, my lord. So, if this goes, everything goes, my lord. So, my technical bid cancellation was arbitrary.
This ITC certificate they have taken into consideration.
Yes, that's why they say private is not government. Whereas for the same year, my lord, page 50 is the document which I annexed with my tender. If the records are called for, it will be clear. So this is the case, my lord.
That means you are held to be technically disqualified.
And my lord, now I'll show my lord what extent of favor they have done to the other side. Now, my lord, kindly.
Are you aware of the financial bid? Their financial bid.
And financial bid to much higher than us. Because, my lord, we are a reputed firm in the country. Otherwise, firm like ITC not place orders with us. We are not typical government contractor. Now, I'll just show one thing, my lord.
If on price your bid is lower,
yes,
then what can tell us? Just discussing what relief can we grant?
No, my lord. Question is, my lord, if they are beneficiary of an illegal order, they will not get the bill. They will not get the bill. Even, my lord, section 70 of the Contract Act will not come to their rescue. Or else, my lord, if your lordship, of course, lordship cannot grant the work to us.
That is the
There
thing.
are two ways, my lord. Lordship can set aside the work order or hold that my technical bid evaluation was improper, in which case they are bound to consider our case. But now the fact that they have already supplied.
Supply has already been over.
Therefore, my lord, will be at liberty to file civil suit and claim damages based on the observation to be made by
And we can also put, we have not heard them, we can put some embargo on the clearing of the bill.
Yes. Yes.
We can direct some inquiry also.
Yes. And quality, my lord. And my lord, kindly just one more aspect, my lord. If your lordship would kindly take the writ petition, page number 79. That is the delivery schedule, my lord, page 79 of the writ petition.
79.
Yes. The bidder has to start supply within 30 days from the date of receipt of the work order to the places of delivery laid down in section 13. Bidder has to complete the delivery of the ordered quantity within 45 days, office working days from the date of receipt of the work order, the places of delivery laid in section 13. Therefore, my lord, it is 45 days. Now, my lord will kindly come to page 73. The consequence of delay in supplier's performance. Initially, my lord,
Page 40.
page 73, my lord. Please come to 20.1 at page 73 towards the bottom. Delivery of goods and performance of services shall be made by the supplier in accordance with the time schedules specified by the purchaser in the schedule of requirement. Then, my lord, 20,
Which clause?
my lord, 20.1 at page 73.
Yes.
Delivery of goods and performance of service shall be made by the suppliers in accordance with the time schedule specified by the purchaser in the schedule of the requirement. Then, my lord, kindly come to 20.3. Except as provided in GCC 23, a delay by the supplier in performance of his delivery obligation shall render the supplier liable to imposition of liquidated damages pursuant to GCC clause 20, unless extension of time is agreed upon pursuant to GCC clause 20.2 without application of liquidated damages. Then, my lord will kindly come to page 20, next page.
74.
Yes. Next page on top. Subject to clause GCC clause 23, if the supplier fails to deliver any or all the goods or to perform the services within the period specified in the contract, the purchaser shall, without prejudice to other remedies under the contract, deduct from the contractor price as liquidated damage a sum equal to so and so per day of the delivery price, and delayed goods or underperformed services for each day or part thereof of a delay until actual delivery or performance up to a maximum delay of 15 days. Once maximum is reached, purchaser may consider terminating the contract pursuant to the GCC clause 24. However, if the performance is continuously found to be unsatisfactory, the rate of deduction of performance security will be enhanced at the discretion of the purchaser, or purchaser reserves the right to cancel the order. 22. The purchaser may, without prejudice to any other remedy of breach of contract, by written notice of default, send to the supplier, terminate the contract in whole or part, and may blacklist the supplier, etc., etc. Now, my lord will kindly take their IA. If your lordship would kindly take the IA filed by them.
I 2714.
Yes, sir. Number. Yes, 2714. My lord will kindly come to page 29. First come to page 23, my lord. Page 23 of the IA. Oh, 15.3. 15.3.22. Now come to 29.
No, we are in page 23.
Yes, my lord. 23, there's the supply order.
It's not 25.3.
It's 15, my lord. No, I think it will be 25, my lord. It's 25, my lord. But 25, page 25, it is 25.
Looks like 25 only.
Yes,
right,
yes,
sir?
25. 25. 25. Now kindly come to page 29, my lord.
This is what?
Yes. Page 29, kindly see, my lord, when they have supplied. 24/8/22, after 5 months. Whether liquidated damage has been imposed, whether beyond 50 days the contract is liable to be terminated. And my lord, this party, if your lordship causes an inquiry, you'll be surprised to know there is the doubt whether this party exists. Progoti.
Why?
Our information is, it does not exist. In papers only it exists. After all, it has to be a manufacturing unit, my lord, of producing notebooks and what do you call it, copies.
There's a new trend
Yes, new trend.
in the High Court. There is no petitioner cases going on.
Yes. Nowadays, my lord, we are compelled to withdraw from it. When our conscience do not permit, we say take the NOC and get away.
No, the other day we were confronted with a case.
Yes. 6
years.
Huh.
6 years case was on from 16 to 22. 23. We have referred the matter to Bar Council, closed it with cost of 50,000 on the council. Because council was vouching that petitioner was there. JD report was otherwise. Allegations against present judge or different High Court.
So, my lord, my termination of the technical bid is on a ground which is non-existent, prima facie. So, my lord, they have taken note there.
What was written in your rejection?
Page 100. My lord, I am worth 100 crore and they want 1.37 crore. Page 100. My lord, in the name of that leeway, my lord, they are taking too much of advantage. Page 100 or 101, same thing, my lord. 3, serial number 3. In this case, it is, my lord, 3. SLPC has examined the documents and evaluation.
You are Progoti.
No, my lord, I'm JC Stationery. I'm JC Station.
100.
101, my lord. Same thing, it is in respect of there are 2 other petitions.
You're JC.
I'm JC Stationery, serial number 3. The SLPC has examined the documents and evaluation statement. After scrutiny and verification of the evaluation statement, evaluated by the evaluation committee, the state level purchase committee observed that the bidder has submitted uploaded information on past supply from government department for 2 years and 1 year from private, submitted certificate of completion of delivery from private organization instead of government semi-government office. Bank solvency certificate submitted in favor of state project Samagra Shiksha Andhra Pradesh. My lord, my bank insolvency certificate is at page number, my lord, 106. Kindly see, my lord. This is to state that to the best of our knowledge and information, Messrs. JC Stationery Private Limited, office at so-and-so, is our customer and be treated as good to sum of 40 crore. And the requirement is 1.37.
No, what is this bank?
It's a, my lord, it's a bank from Andhra Pradesh. My lord, that's why I refer to their clause 16.1.
This is the bank.
Yes, my lord. Mercantile Mutual Cooperative and Credit Society. It's a financial institution. FI. They are not rejecting our technical bid on the ground that bank insolvency certificate is not acceptable.
That is one of the ground.
No, they say, my lord, they say that this is issued in favor of this state project director Samagra Shiksha Vijayawada. It is not shown that to be, I mean, in favor of the Sarva Shiksha Obhijan Mission Ahom.
When you
My lord.
find,
My lord, towards the end, it is clarified that this information is furnished without any risk and responsibility on our part in any respect
okay.
whatsoever, more particularly either as a guarantor. This is the normal language, my lord. Certificate is issued that this specific
But
request.
this
of-
is not for this thing.
No, my lord. No, question is, my lord, they want to know whether what is my financial solvency worth. This certificate very much, my lord, says that I am financially worth. That they could have sought a clarification under 16.1 that you have given a certificate of this. Will it cover our risk or not? It would have been enough. Because by that, my lord, they would not have tinkered with my price or quality of supply. And my lord, the ITC supply, they have taken note of at page 57, whereas at page 50 for the same year, I have made a supply of, my lord, 7.22 crores. So in these circumstances, I will respectfully submit, my lord, the rejection was arbitrary. This is my case, my. And if your lordship would kindly come to page 82, my lord, regarding
We come to 101. Let us test again the three.
yes. Page 100, my lord.
101.
101, yes. 3. SLPC has examined the document and the evaluation statement. After scrutiny and verification of the evaluation statement evaluated by evaluation committee, the state level purchase committee observed that the bidder has submitted, uploaded the information on past supply from government department for 2 years and 1 year from private. Submitted certificate of completion of delivery from private organization instead of government, semi-government. That is one. Bank solvency certificate submitted in favor of State Project Director Samogra Shikha Vijayawada Andhra Pradesh. Hence, SLP recommended the bidder is technically not responsive and has recommended that commercial bid be not opened.
Past supply, 2 from government.
1 from
Two.
private.
Government 2 years. 2 years.
They have no dispute with 18, 19 and 2021. They have dispute with 19, 20.
And what do you say about the private?
No, my lord. Private they need not consider because please come to page 50. Page 50. Yes. Supply of notebook to Andhra Pradesh so-and-so institution for academic year 1920. Supply is completed, releasing on payment for supply of notebook to JC Stationery.
Where are you reading? Page 50?
Page 50 on top, my lord. Subject.
Yes. Supply of notebook, please.
Supply of notebook to so-and-so institution for academic year 1920. Supply is completed, releasing of payment for supplying notebooks to Messrs. JC Stationery Private Limited. Sanction accorded 7 crore 22 lakhs 44,000 and so and so. Now what they have taken note of is, my lord, page 57. Additionally, my lord, we gave this document also in support of our, my lord, experience.
That is to ITC.
Yes, ITC.
It's for the same year.
So this is for the same year.
1820,
Yes.
1920.
Yes. Because
Now, where are your other for the other 2 years?
yes, other 2 years, there is no dispute. They don't dispute
No,
others.
but they have not stated the 1890.
Oh, yes. Anyway, my lord, I'll say. Page 24. For private party, we have given document only for 1920. page 24, this is for 18-19. Supply of notebooks to the social welfare hostel boarders for the year 18-19. Payment of rupees 4 crore 93 lakhs and odd. So and so towards notebook for so and so sanction order.
24.
Yes. This is for 18-19. And for my lord 2021 is at page 29. We, JC Stationery, have all successfully completed additional order given to us against tender number so and so. We thank you for the opportunity given to us to serve your esteemed department. Herewith, we are submitting the bills along with the acknowledged delivery challenge for your kind approval and submit request for release of the payment. 75 crore, 76 lakhs, 10,000 and all.
But this 29, this is not their letter.
No, my lord, this has been acknowledged also, kindly see, by the department.
But any case, they are not finding fault with this.
No, they're not finding. They're not finding fault with my lord 18 and 21. They're finding fault with 19-20. Because my lord, ITC order was given only for the year 19-20.
Samagra Shiksha, they cannot find fault.
Yes. Now regarding that bank solvency certificate. Yes.
That's 101 again. So they have not specified the years.
Yes.
It has to be presumed that from private means the ITC.
Yes.
For which you said that apart from ITC,
Yes.
which can very well be ignored,
Ah.
you have made supplies to the Andhra Pradesh government
Yes. Yes.
and more than 7 crores.
Yes. While the requirement was for only 1.37 crore.
Okay, next.
My lord will kindly come to page 82 regarding the bank's insolvency certificate.
That we have already seen.
No, kindly see, my lord, page 82, the requirement. Serial number 36. Bank solvency certificate. That it should be in a particular form. Nothing has been, therefore, my lord, they should have taken recourse to clause 16.1. They say we should furnish a bank solvency certificate. We have given a bank solvency certificate. That it should be in a particular form, that it should be placed in favor of so and so. Nothing is indicated. We have experience of supplying 30 crore copies. The requirement is totally 26 lakhs. If they would have said that you are a big party, why are you coming here? Then that should have been a different. So, my lord, I am relying on that West Bengal case, State of West Bengal State Electricity Board versus my lord, Patel Engineering, that 2001 to SCC 459 para 24. The Supreme Court says, my lord, the best way to achieve transfer is to follow the tender condition. Apparently, they are not following the tender condition. Your lordship orders an inquiry, my lord, everything will come out of the cupboard. Things are not going in the right direction. I think, my lord, in 1 or 2 cases, lordship should test it. Because in the name of that leeway, my lord, they are doing too much. In every case, my lord. They are using police to harass the, petitioners, my lord. I'm making this statement with some sense of responsibility. In that, my lord, that Jagirod case, our clients were harassed by the police. My client's factory in, my lord, Prolasbari, my lord, it was dug out so that my employees cannot enter. That's why they have withdrawn it. They asked me, I said, I'll not do. Then I said, I'll give NOC, do it to somebody else. They have done it. Things are not going in the right direction.
Lordship, in case number 1878, we have.
Why 4 cases?
3 cases, my
Why
lord.
3 cases?
Lordship, various supply for various classes, Lordship.
Okay.
From class.
Requirement is almost the same.
Same.
Lordship.
3 cases for 3. Huh?
Lordship, in
You appear as SSS. For 3 categories of classes.
Lordship, in case number 1878, we have filed our affidavit, Lordship, my colleague.
Yes. So you can just meet the case has been ultimately projected in a very, very simple thing. 2 of the criteria which the petitioner should have met. You said that they have not met. They have been disqualified on non-fulfillment of 2 criteria.
Yes.
First is that for 3 years they need to have certain past experience.
Yes, Lordship.
And 1 year you have said that it is from a private organization, ITC. And Mr. Chaudhary has said that on the same year, there is also a certificate from a government agency.
Lordship, that's
And the second one is regarding the bank insolvency certificate. He says that since 82(3) does not give any specific format or pattern, a normal certificate of this kind should have served the purpose.
Or they could have sought clarification.
Lordship, with regard to taking into account the previous experience of supply, 2 years government, it's no problem, Lordship. Now the petitioner is relying upon page 50. Lordship, whether that institution, Andhra Pradesh Social Welfare Residential Educational Institution, is a government or semi-government, Lordship, as it is being projected, Lordship. Where it is mentioned, then it's a government or semi-government institution. So whether we can take this into account.
50.
Page 50, Lordship. That Annex 6, Lordship, under proceedings of the secretary. Lordship, I'm taking up 1878 page. Nowhere it states that it's a government or semi-government, Lordship. And Lordship, from Annex 7, it appears that it's a society. What type of society, Lordship? Nowhere the petitioner has stated in the pleadings also that that is a semi-government.
Yes.
Lordship, so even if that has been taken into account by the state level committee, Lordship, tender committee, Lordship, that doesn't reflect that it's a government or semi-government supply order. And similarly, Lordship has seen the ITC work order, Lordship. That is a private organization. So number 1 point, Lordship, out of the 2 points, rightly rejected that since he has supplied only
That was for 19, there is no government.
no government, Lordship. Over 2 years, he has supplied, that has been taken into account. But since 3 years experience is required, Lordship, neither 1 year he could have made any explanation. Second point is, Lordship, with regard to the solvency certificate. Lordship, may kindly peruse the solvency certificate.
Page
82, Lordship.
$82 is the requirement.
No, Lordship. Lordship, it will be 106, Lordship. Lordship has seen the eligibility criteria where it is written that only bank solvency certificate. Lordship, I may be allowed to read it. This is to state that to the best of our knowledge and information, Messrs. So-and-so is our customer and be treated as good up to sum of rupees 40 crores. It is clarified, Lordship, mechanically clarified, that this information is furnished without any risks and responsibility on our part in any respect whatsoever, more particularly either as guarantor or otherwise. This certificate is issued at the specific request of our customers, Messrs. JC Stationery Private Limited, to submit the State Project Director Samagra Shiksha Vijayawada, Andhra Pradesh. Lordship, it clearly shows that it is only specific to that particular work. Can this be taken into account for every work thereafter, Lordship? It is not specific. Therefore, up to so many years, this will have an effect. And Lordship, at the last line, it is stated, this certificate is valid up to 12 months from the date of issue. Taking these two criteria, Lordship, the tender committee rightly rejected the petitioner's claim in the technical way, as he was not eligible, Lordship. And Lordship is aware, I'm not going to repeat it again, Lordship. Whatever the tender conditions are there, particularly with regard to the eligibility, it has to be followed by the committee. And these two grounds only, Lordship.
You can reframe that tender conditions per se are not put to challenge.
Yes, Lord.
He is only saying that he is, by this he fulfills. The rejection by holding that he has not fulfilled is not correct. That is his contention. Now you have, so far as 19 is concerned, you said this organization cannot be said to a government organization.
Yeah.
So even if you ignore ITC, even this will not help the petitioner. And insolvency is for Samagra Shiksha Vijayawada, not for this project.
Particular project.
Not for this project. Have you given a original of this, Mr. Chaudhary?
Yes, my lord.
106 with the bill?
My lord, let them produce the record, everything will be clear. What about tender contain, that record will reveal. Record will also reveal, my lord, what are the eligibility of the person who has been given.
But that you have not put to challenge.
Which one, my lord?
The other persons who
No, we have challenged. Of
have
course,
you- have you
yes,
questioned?
yes.
You have not addressed. You only said that they are not.
No, my lord, if I succeed in establishing that my technical bid was improperly rejected, then I'm already entitled to a consideration. Because the fact that
So if you are making a serious allegation against the private respondent, you
Yes,
can
yes.
address this court. You said that they are non-existing kind of a thing.
No, my lord, when we approached this honorable court, at that time, my lord, work order was not issued. We approached immediately against our rejection of our technical.
Correct, correct.
My lord,
Subsequently, they are given.
by filing an additional affidavit, we have brought on record.
Yes.
If your lordship will kindly take the additional affidavit, my lord.
We'll come back to you, Mr.
Yes.
As a rejoinder.
Yes.
Anything else? Anything else?
No, but lordship, only these two grounds of rejection and lordship from their own.
Tender conditions needs to be followed.
Yes, lordship. And
You have
from-
already done that.
Yes, lordship, and from their own document, it reveals that they have not fulfilled the 3 years criteria for supply. And the solvency certificate also, lordship, we can take it that it was never produced because this certificate, lordship, clearly specify it's only for a particular project of another state.
You have the records
Lordship, there was no direction.
and
for
you have the records otherwise.
Yes,
We
Lord.
wanted to have a look at the origin, whether origin could have been given to you.
Yes, lordship.
But if it is for another organization, it not make much of a meaning if it's given to you.
Because the language of the certificate clearly states it is at the specific
It is
request for a particular work.
For state project director, Vijayawada.
Vijayawada, Andhra Pradesh.
Okay.
Because the one word is to submit.
Mr. Borbuje, you are for whom?
I am the beneficiary.
And madam is also beneficiary. Together.
Together.
Respond number?
Respondent number here, my lord, 6.
And rest 2 cases? Same, you are the respondent.
Yes, I'm respondent, my lord. And in one cases, my lord, we are for PP Bafna.
For
PP Bafna Ventures Private Limited.
private respondent.
Private respondent. Otherwise, my lord, all the beneficiaries, my lord, who have been awarded the contract, my lord, the work order, we are representing, my lord. They are duly represented. And that my lord, we have filed, my lord, taking the leave of this honorable court, my lord, for releasing that payment. In that my lord, we have raised the contentions, my lord, reversing the, my lord, stand taken by the writ petitioner in the writ petition, my lord.
So what is your case?
So first of all, my lord comes to the prayer portion of the writ petition, my lord. Prayer portion, my lord, that page 17.
17.
17. Well, I am taking up my lord WPC 1877.
18, don't take a vote.
Yes, 1877.
Yes, 1877.
1877,
Yes,
my
sir.
lord. There, if my lord comes to page 17. The first prayer is, my lord, a writ in the nature of certiorari for setting aside the minutes of meeting. They are challenging the decision. And the second prayer at page 18. The writ of mandamus shall not be issued directing the respondent to consider the commercial bid showing. It is not the case of the writ petitioner, my lord, that the rejection, my lord, the rejection of the writ petitioner's, my lord, bid, my lord, has occasion, my lord, due to any foul play of the private respondents. Number 1. Number 2, my lord, the statement that has been made at the bar sometime before, that the petitioner, my lord, the private respondents are non-existent entity. My lord, they have duly participated in the bidding process. At no point of time, my lord, they had raised any objection to that effect. Now, my lord, they are estopped by the, my lord, principle of waiver, estoppel and acquiescence. They have acquiesced, my lord, to the, my lord, the private respondent taking part in the bidding process and having succeeded in, my lord, getting that contract. They have only, my lord, questioned the genus of the, my lord, the entire, my lord, the sequence of events. Now, in the meantime, my lord, after having awarded the contract, my lord, the private respondents have duly made all the supplies, my lord, and the supplies are all the supplies are completed. All the supplies are completed, my lord. There is no complaint whatsoever from any corner that, my lord, there is the supplies that, my lord, the exercise books which have been supplied, my lord, are not, my lord, are of inferior quality or they do not match up to the mark, my lord, as has been, my lord, laid down in the tender documents. It is not those case of the petitioners, my lord. It is only for the first time, my lord, these statements are being made at the bar. So therefore, my lord, my respectful submission at this stage is, my lord, it is devoid of any pleadings.
Other matters not possible today. Even this matter, if want to review a rejoinder, we can fix it tomorrow. How long will you take, Mr. Prabhuchari?
My lord, only 15 minutes, my lord.
Tomorrow. Tomorrow you can give a small rejoinder also.
Okay.
You are relying on any decisions.
Yes, my lord.
Come with a fresh mind.
No, no difficulty, my lord.
Hearing remain inconclusive. List for further consideration tomorrow. It will take my by script. Oh, কালি যদি মোশন না থাকে, মোশনের বিষয়ে একটু ফার্স্ট। That's what case admission. The first admission. We'll take this immediately after the motion.
My lord, I'm so
But
grateful.
not much time. Maximum.
Take 5 minutes time.
No, my lord, I will only take, my lord, 15 minutes, and I will only.
Not, don't need 15 minutes. Because if in rejoinder he makes certain allegations against you, then we can give you another chance. But now you just can generally address that you are also eligible in the respect. You can, your papers, documents, you can show.
Yes, my lord, definitely, my lord. I will try to call out my case from the documents itself, my lord.
Any matters were interim order till today?
I'm so grateful.
Mr. Aludar, Mr. Mitra, any matter?
I have matter, but only thing is that some correction has to be made in the order.
We'll make the correction. Item number?
Item number 53, madam.
Yes. What is the correction? Tell us.
Yes, that
Mr. Aludar, any correction there? Agreeing?
that actually the Dagna pattern number is some correction that already out of the past. I just read out, my lord. Actually, it should be the owner of the land marked as 363, not just 363. It should be 400. And the land acquired.
Mr. Mitra, 52, I think, not 50.
52. 52.
Madam, is there any error in the order?
Yes, Lordship, the dark number, Lordship.
Okay. You have gone through the petition.
Yes, in this IA.
Yeah, you don't have any issue, objection? Third. The S. Mitra, current counsel for the applicant, who by means of this petition has paid for correction of an inadvertent error, inadvertent typographical error occurring in the order dated 9/12/2022, passed in WPC 54500/2022, correct?
Yes,
The Learned Council has submitted. What is the?
Yes, my prayer portion, I like that the error is under section 3 of the National Highway Authority Act, content DAG number 360 and not DAG number 400. So it is
Where?
notice is issued under 360, no, not 400. The applicant is the notice has been issued under section under 3A in DAG number, particular DAG number 363.
Where is the correction required? Which paragraph?
Yes, madam. I got it.
Paragraph 8.
8. Yes, ma'am. My lord.
My lord.
Yes, my lord. Page 8. Paragraph 8. The Lana Chutia, Sri Chutia Lanas Standing Council, KSC, submitted fact have not been projected in the correct manner. He submitted, though it is the fact that land has been acquired, the petition right came into being after so and so, so and so. The understanding is emphatically submit that after publication gazette, wherein land under Dagna 400 was sought to be acquired by the petition as purchased a plot of land. So, my lord, what happened actually? From the original petition, however, new Dagna was 360. It's not a new 360, it should be 400. And the wherein land was sought to be acquired, the petition
363 is the land. Is the 360 land is the house have seen the plot of which is newly marked. It is also part of the acquisition proceeding and was originally part of Dagna 404. The remainder period lie in section.
You
3.
just tell us the portion which needs to be corrected. Where are you reading everything?
Yes, my lord. I just read out.
We have referred 400, 350, 63 in the paragraph.
Yes, as a consequence thereof, all further community happens to be to be in the name where refers to be old Dagna 400, which is recorded by NSC was included in 3-year notification. In 3-year notification, 400 was not included, 363 was included. And the land technicals of submitted in the plot of which are newly marked is also a part of land for acquisition process. Newly acquired for Dag number is 400, my lord.
Where, which page?
It page, my lord, in the judgment annexer, my lord.
Page 12, my lord, paragraph 8.
Yes, paragraph 8.
Yes, which part?
Lordship, the fifth line. The fifth line, seventh.
We read from one line above, the learned standing council, emphatically, correct?
Yes, my lord.
Submits
That
that after publication in the Gazette, wherein land under diagram of 400.
it should be 363. Next.
And paragraph 12 also, my lord. Very last.
Now what 363, then what is the second 363? If you continue, read continuously below.
363 and Dag number so and so, however, was created as new Dag number and numbered as 363. It should be 400, my lord.
Reverse.
Reverse. And that thing has been, my lord, if you lordship go
New
through-
Dag is 400.
Yes, my lord.
And the old Dag should have been 363.
363.
And the new
And
is.
thereafter also, my lord, thereof all further communications happen to be name of where reference to the old Dag number, that should be 400, but it should be 363, my lord.
Well, if you lordship go to the last paragraph, my lord, that will clear, my
You're
lord.
right, you're right. Heard. S withdraw. Learned counsel for the applicant who by means of has submitted that due to inadvertent comma, there has been mistake in writing the Dag numbers. Full stop. It has been submitted that the original Dag number was 363. Mr. Talukdar, original Dag number was 363.
363, my lord.
And the new Dag which was created
400.
is 400. Full stop.
400.
Accordingly, comma, it is directed that wherever Dag number 400 has been mentioned in the judgment, the same should be replaced by 363
360.
and vice versa. That is, wherever
Yes.
Dag number 363 is written, that should be read as
400.
400.
400.
It's clear. Later on also there will be
Yes, sir.
change.
Paragraph
Paragraph
12.
12.
Paragraph 12.
If you lordship go to paragraph 12, this is clear. It appears the initial notice of the section 3A indeed contain only Dag number 400 and not 360. It is reverse. It is reverse. Notice issued as 3A.
So here, correction in paragraph 12 will be necessary or not?
Yes, very much necessary.
Same.
Same.
The to remove all confusion, comma, the order passed today should be read as a part of the original order dated so and so. Asked and everything. I stand this order.
Lordship, my presence may be shown, lordship. I am for respondent number 2 and 7.
And madam,
RK Talukdar for 2 and 7.
madam,
4,
you,
5 and 6.
your name?
On B show hai.
B?
B show.
Put, give your name, okay?
B I am.
3. Foreman. Huh? Okay.
Full husband.
This week, court must have, court made say, you know that it's Court master will give, don't worry. Is there any interim order? Then. Take me here to whatever. Last case too. I see.